morning. Today is Thursday, February 17th. This time and place was regularly scheduled Nevada Gaming Commission meeting for February.
Your mic.
All right, I'll start over just for the recording purposes. Good morning. Today is Thursday, February 17th, and this is the time and place for the regularly scheduled Nevada Gaming Commission meeting for the month of February. Please rise and join us in the Pledge of Allegiance.
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. Madam Secretary, has our agenda been posted in accordance with the open meeting law?
Yes, it has.
All right, at this time, I would like to remind anyone coming to the podium to speak. We ask that you speak directly into the microphone, speak as clearly as possible, as this meeting is being transmitted electronically and being transcribed. Madam Secretary, let's proceed with our first agenda item, public comments.
This item is placed on the agenda to give the public an opportunity to comment on gaming-related matters.
Anyone who wishes to address the commission may do so at this time. Matters brought to our attention during public comment cannot be acted upon, but we are happy to hear comments of the public as well as my fellow commissioners. Comments by all will be limited to 3 minutes as a reasonable time, place, and manner restriction. If any of my fellow commissioners or myself ask questions of the public, the time needed to address those questions will not be held against those time constraints. I'll first go to Carson City. Anyone wishing to make a public comment, please step forward to the podium. There being no one, anyone in Las Vegas? There being no one wishing to make public comment, that will close our public comment section. Madam Secretary, the next item on our agenda is the approval of the prior month's disposition.
Pursuant to NRS 241.035, this item is the consideration of the approval of the Nevada Gaming Commission disposition for January 2022.
So I believe each of us has had the opportunity to review the disposition. If there are no questions, I think it is in proper form for a motion.
Thank you, Madam Chair. I move for approval of the prior month's disposition.
Any discussion on the motion? There being none, all in favor, say aye.
Aye.
And there are none opposed. All right, we have no items on non-restricted consent this morning. Please note for the record, we have item number 4 that was referred back to staff by the Gaming Control Board. Madam Secretary, please read in the restricted consent items.
Your items on the restricted consent agenda this morning are items 3 through 15. The recommendation of the Gaming Control Board is for approval with the conditions as noted on the agenda.
Are there any questions of the members of the commission on any of these items? There being none, I think they're proper for a motion.
I would move for approval of the consent agenda items on the restricted agenda 3 through 15 by the recommendations as set forth by the Gaming Control Board.
Any discussion on that motion? There being none, all in favor of the motion, say aye.
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 It appears there are none opposed. Madam Secretary, please read in our new game consent item.
You have one request for final approval of a new game. That item is Keep It Straight Second Chance, submitted by Creative Dream Gaming, LLC. The recommendation of the Gaming Control Board is for final approval.
Are there any questions on this item? Comments? There being none, does anyone have a motion?
Sure, Chair Tagliati. I move for approval of the new game Keep It Straight Second Chance as recommended by the Gaming Control Board.
Any discussion on the motion? There being none, all in favor, say aye.
Aye.
Aye. All right, there are none opposed. Thank you. We have non-restricted items held out for discussion at this time. Madam Secretary, if you could read in non-restricted number 1.
Non-restricted number 1 are the applications of Las Vegas Sands Corp. For an amendment to their order of registration, Las Vegas Sands LLC for licensure as sole member and manager of Venetian Las Vegas Gaming LLC, Venetian Las Vegas Gaming LLC doing business as the Venetian Resort Las Vegas for a non-restricted gaming license, licensure to conduct off-track pari-mutuel race wagering, licensure to operate gaming salons, licensure as a manufacturer and distributor, and licensure to receive a percentage of revenue from WHNV3 LLC as noted on the agenda. Lastly, of the applications of Robert Glenn Goldstein, George Minas Marcantonis, Lance Paul Goutreau, and Daniel Richard Parks for licensure as key executives. The recommendation of the Gaming Control Board is for approval with the conditions as noted on the agenda. I believe we have disclosures and/or recusals on this item.
Thank you, Madam Chair. NRS 281A 420 requires me to make a disclosure on this item. Matter before this body relates in my commitment to, in a private capacity, to the law firm of McDonald Carano, where I'm an employee. McDonald Carano performs some non-gaming legal work for the Las Vegas Sands Corp. None of those matters are related to the item before us today, do not affect me personally, and that the independence of judgment of a reasonable person in my situation would not be materially affected by this relationship, and making me prepared to participate in this matter today.
Okay, thank you.
Thank you, Madam Chair. With respect to non-restricted item number 1, I'd like to disclose that I'm a partner at Morris Law Group, and my firm and I have previously represented Las Vegas Sands entities in unrelated litigation, all of which concluded a number of years ago. I have no pecuniary interest in the item before us, and I do not believe that the independence or judgment of a reasonable person in my situation would be affected by the relationship. I intend to participate in deliberation and voting on non-restricted item number 1.
Thank you so much, Chair. In connection with non-restricted item number 1, Louis Roca, the firm where I am a partner, represents Las Vegas Sands LLC, in which representation I'm not personally involved. The parties to the application today, it's an entity by different name, Las Vegas Sands Corp., but in an abundance of caution, I make this disclosure. But Louis Roca is not representing Las Vegas Sands LLC in connection with the application pending before the commission today. I have no pecuniary interest in the outcome of the agenda item, and I do not believe the independence of judgment of a reasonable person in my position would be affected by the relationship described on the record, and I therefore intend to participate. Thank you.
There being no other disclosures, welcome. Please state your name for the record.
Thank you. Good morning, Chair Togliatti, Commissioners. For the record, I am Mark Clayton, and along with Eric Oakberg, we are Nevada Gaming Council for the Las Vegas Sands. First, Chair Togliatti, we'd like to thank you for the professional courtesy of waiving Mr. Goldstein's appearance at the hearing today. We believe his comments presented before the board created a robust record, and so we do appreciate that courtesy. This application we are before you today is in connection with one minor part of the overall transaction that is captured in item number 2. Specifically, the assets of the current gaming licensee, Las Vegas Sands LLC, will be transferred to a new entity, Venetian Las Vegas Gaming LLC, which will then be licensed if the commission so approves, and then subject to approval of item number 2, would then eventually be transferred to Apollo as part of that transaction. This is separately agendized because the asset transfer and the licensing of the new entity will occur a moment in time and will be owned by Las Vegas Sands, and that entity is immediately then transferred to Apollo as part of the acquisition model that was put together. There are various individuals on the application. The gentlemen listed on the agenda have previously been licensed and have appeared before the board and the commission. Each of the applicants is seeking approval for effectively the same position they hold today, just with the new legal entity. Post-closing, Messrs. Marcantonis, Gautreaux, and Parks will stay with the property of the gaming licensee, while, as Mr. Goldstein indicated, he will continue with Las Vegas Sands Corporation. As each of the individuals are existing licensees and are familiar to the board and the commission, and the roles have not changed, we have no specific affirmative update on the individuals regarding their duties and responsibilities. However, obviously they're here if there's any questions. And with those few remarks, I'll stand for any questions the commission may have.
Just as a procedural point before I open it up for any questions or comments, there's a lot of materials provided to us related to these agenda items, and I want to make sure that the 6th revised order of registration is what you've reviewed as the most recent. Is that what you're?
Yes, draft
requesting?
number 1 of that's correct.
Okay.
Draft number 1 of the 6th revised order is, as well as the additional conditions that the board recommended. We've obviously, Apollo will be living with those conditions, so we liaise with their gaming council, and they are in agreement with those conditions, and we have no obligation or no objection to them as well. For the
Okay,
sake of the record.
thank you. Do any of the members of the commission on this particular agenda item have any questions or comments? In light of my guess being that we're going to have the bulk of the exchange on the next item, it appears that this item is ripe for a motion. Yes.
I'm happy to make a motion on this item. I would say that as a part of the sort of more global discussion, I hope that this is not a goodbye to Las Vegas Sands operating in Las Vegas and on the Las Vegas Strip, and it's moment merely a see you later. Um, but understanding that everyone makes their own private decisions, certainly ready to make a motion if you're ready for it.
Is your mic on?
Thought it was.
Sorry.
Thank you.
Madam Chair, I would recommend that the commission approve non-restricted item number 1 as as recommended by the board and read into the record by secretary.
Any discussion on the motion? There being none, all in favor say aye.
Aye.
It appears there are none opposed.
Thank you.
Madam Secretary, can you please read in non-restricted number 2?
Non-restricted number 2 are the applications of AP9 Pioneer Vote Co. LLC for registration as a holding company and for findings of suitability as general partner of AP9 Pioneer Holdings LP and sole member of Pioneer Topco GP LLC. It's also the applications of AP9 Pioneer Holdings LP, Pioneer Topco GP LLC, Pioneer Management Holdings LLC, and Pioneer Management Co-Invest Holdings LLC, Pioneer Topco LP, Pioneer Midco LLC, Pioneer Holdco LLC, and Pioneer Opco LLC for registration as an intermediate company or private investment company, for finding of suitability as a limited partner, general partner, managing member, sole member, waiver of Nevada Gaming Commission Regulations 15C.210 or 15C.0101A and or the pledges as noted on the agenda. In addition, you have the applications of Venetian Las Vegas Gaming LLC for a transfer of interest, and lastly, the applications of David Samber and George Marcantonis for finding of suitability as managing member, manager, and or a key executive as noted on the agenda. The recommendation of the Gaming Control Board is for approval with the limitations and conditions as noted on the agenda. I believe we have disclosures and or recusals on this item.
Thank you, Chair. I do have a disclosure for non-restricted item 2. Las Vegas Sands LLC is a client of Louis Roca, the firm where I am a partner, in which representation I'm not personally involved. The party to the agreement today in relation to this application is an entity by a different name, Las Vegas Sands Corp. But I make this disclosure again in abundance of caution, as I did previously, as Louis Roca is not representing Las Vegas Sands LLC in connection with the application pending before the commission today. I have no pecuniary interest in the outcome of this agenda item, and I do not believe the independence of judgment of a reasonable person in my position would be affected by the relationship described on the record, and I therefore intend to participate. Thank you.
Thank you.
Thank you, Madam Chair. With respect to non-restricted item number 2, I again disclose that I'm a partner of Morris Law Group. My firm and I have represented several Apollo entities in prior litigation, 2 civil matters where I did limited work and which are unrelated to the matter before us. One concluded a couple years ago. The other one is pending before the Federal District Court in Nevada. The matters had nothing to do with the issues before us, and my involvement, like I said, was limited. The revenues generated from that representation are not material to the firm, and the matters did not reach discovery. So I do not have any information before me other than what was presented to us by the presented to me and all commissioners by the Gaming Control Board and what I heard in the public meetings. However, in reviewing the entities that are currently part of the litigation, there's a number of them. I represent 4 of them: Apollo Global Management, Apollo Investment Funds 8 LP, Apollo Gaming Holdings LP, and Apollo Gaming Voco LLC. They're referred to generally in that litigation as the AGM defendants, although I do not believe the independence or judgment of a reasonable person in my position would be affected by this relationship, because that matter is ongoing and one of the parties is before this commission. I am going to recuse on this matter.
Okay, thank you.
Thank you, Madam Chair. I'll like to disclose again that I'm an employee of the law firm McDonald Carano. The firm does provide legal work for Las Vegas Sands in non-gaming related matters. The final application on non-restricted item number 2 is the transfer from Las Vegas Sands to Pioneer Opco. My law firm had no interest in this matter, and it does not affect me personally. As such, I conclude that the independence of judgment of a reasonable person in my situation would not be materially affected in this relationship. I'm prepared to participate and vote on this matter today. Thank you.
Thank you. Okay. At this time, could you state your appearance for the record, please?
Yes, Madam Chair, members of the commission, Madam Secretary. Frank Schreck, together with my partner Sonia Vermaze from Brownstein Hyatt Farber Schreck. We're here on behalf of the applicants. With the chair's permission, it's our intention to make a formal presentation to the commission. I think we provided the commission with copies of our presentation booklet. I'd request the chair make that booklet confidential and not have it made part of this record, public record. Before we begin our presentation, I'd like to introduce the Apollo team that's present, and also we should have one that's joining us by video.
Hey, do you hear me, Frank?
There we go. Yes.
Okay.
First, the person just speaking is David Samber. He joined Apollo Management, Global Management in 2004. And since that time has risen to his current position as co-lead partner of private equity. David is currently licensed in Nevada with Play AGS. He'd been previously licensed in Nevada with Caesars Entertainment. He is now or has been licensed in over 20 jurisdictions throughout the United States, as well as in Canada and Australia. David is seeking licensures as Madam Secretary read into the record, licensure as a sole managing and controlling member of AP9 Pioneer Voteco and LLC, and he's also seeking approval as a member of the Board of Managers of Pioneer Topco GP LLC. With us today, individual that couldn't be before the control board because of these issues, coming back from Latvia where she was meeting with her family, is Monta Ozolina. Monta is a principal at Apollo. She's an important member of the deal team and is a member of the board of directors of Pioneer Topco GP LLC. Monta has filed her application with the Nevada Gaming Control Board, and she looks forward to be part of this presentation today. We also have with us Brian Carney. Brian is General Counsel for Litigation and Regulatory Matters for Global Apollo Management. I met Brian in approximately 2006 when he was outside counsel to Apollo, and we worked together on the licensing of Apollo and TPG in respect of the licensing and the purchase of Harrah's, or now Caesar's Palace, and also with the subsequent purchase of American Gaming Systems, which is Play AGS. It's already been mentioned that George Marcantonis, Lance Gautreaux, and Daniel Parks are here today. They're going to be transitioning under Apollo's management if this application is approved with Venetian Las Vegas Gaming LLC. We have one new team member for that management group, Robert Bremner, who is here today. He will be the CEO pending approval from this commission. He's subject to, he has filed his application and is in the process of being investigation. Rob joined Caesars Entertainment in 2007 after receiving an MBA from the University of Chicago. He began about as low as you could as a president's assistant and advanced to director of corporate finance, then VP of corporate finance, and finally senior VP corporate finance and analytics, and stayed at Caesars until it was purchased in 2020 by Eldorado. With that, Madam Chairman, I would like to ask Mr. Samber if he would begin our presentation.
Thank you.
Thanks, Frank. Chair Togliatti, commissioners, I apologize for not being there in person. I tried my utmost to be back. I had some scheduled travel overseas and for circumstances beyond my control, unfortunately was unable to make it back. Please don't take it as me not trying my hardest, and it was very important that I made every effort to be there in person, and I do apologize. So I'd like to walk you through the presentation I think you have in front of you. And of course, feel free to ask questions. I'll call out the page numbers as I go through it. So first, I'd like to start on page 3. And I'm pleased to discuss an overview of Apollo and why we're so excited about this opportunity to buy the Venetian, which is truly an iconic resort in Las Vegas. So first and foremost, as Frank said, my name is David Samber. I'm the co-head of private equity at Apollo. I've been at the firm for about 18 years. In my capacity, I lead our investing activities for our firm in private equity. And I've also had a personal role in all of our gaming investments. The firm got its start in 1990. We're one of the largest alternative asset management firms in the world, and we manage about $500 billion of assets. And we have about 2,000 employees in 17 offices globally, with our headquarters in New York City, which is where I work out of. If you look on this page 3, you can see our private equity business in blue, which is the business that's going to be making the investment indirectly in the Venetian out of our 9th private equity fund, which is Apollo Fund 9, the $25 billion fund. So what is private equity? That's a question that we got a lot during the Gaming Control Board hearing. And I'd like to talk to you a little bit about our business model. So what we do is we take funds, mainly from institutional investors, and we're on our 9th fund, which is what the Venetian is going to be a part of. And those institutional investors, mainly pension funds and college endowments, corporate and private pension funds, give us equity capital that we use along with borrowed debt to buy companies. And those companies are all operated independently with their own boards of directors and management teams. And our goal in buying these companies is that we grow their value over time and then either take them public or sell them and then return the equity to our investors, hopefully at a profit. Flipping to slide 4, our clients who we take that equity capital from really rely on us to help them meet their obligations, mainly pension obligations. And we think of our role in the economy as being threefold. The first, as being a leading provider of retirement income solutions to institutions, companies, and individuals. This is through our investing. Being a leading provider of capital solutions to companies. And I would say this transaction with Las Vegas Sands is a good example of that. They had a specific need and a desire to raise capital, in this case by selling the property. We were able to design a financing solution with them that helped them meet their objectives. And then finally, being a leading contributor to some of the biggest issues facing the world today, including energy transition and social impact, which I'm going to talk about a little bit later on during my remarks. On slide 5, these are the values of our firm. And in fact, I'm overseas today, but at 9 a.m. this morning, we had our global town hall for the firm, and the CEO of our firm walked through a bunch of these values, and it was great to hear his perspectives on it. We seek to outperform expectations. We believe in pursuing investment excellence and being tenacious and passionate, and of course, operating with integrity. We challenge convention. We try to be creative, and I think this transaction, especially our ability to pull it off at a time of real disruption in Las Vegas, I think speaks to our ability to be creative providers of solutions for companies. We champion opportunity. It's a priority of our firm to really seek diverse perspectives, both from an investing perspective, but also from a social perspective, prize authenticity, and really foster a sense of belonging, both at the firm and in our portfolio companies that we help manage. And then we're a collaborative culture. We really pride ourselves as being entrepreneurial and collaborative, both amongst our deal teams and with the portfolio companies that we're affiliated with. So on slide 6, what we've done here, just to give you a sense of the size and scale of Apollo and its portfolio funds, if you were to aggregate, which we run all these businesses separately, all the portfolio companies that are managed in our current private equity funds, it would make the 15th largest company in the United States with over $150 billion of sales. It just gives you a sense of the scale of the businesses that we're affiliated with. We pride ourselves on having strong corporate governance policies, both at the Apollo level and at the companies that we manage. And I'm going to walk you through a little bit later on, specifically compliance, both at Apollo and for the Venetian. So flipping to slide 7, I wanted to take this opportunity to answer any questions that you might have about our former CEO, Leon Black, and him no longer being at the firm, and any questions you might have about my sole authority as the sole managing member of AIF 9 Pioneer Voco. So first, just to review, and then of course, I'll stop for questions at the end of this slide. I wanted to reconfirm that Mr. Black is no longer an employee of Apollo. He's no longer a director or an officer or has any affiliation with the firm in any official capacity whatsoever. He resigned from all of his roles in March of 2021. He no longer has an Apollo email address, access to our electronic systems, a phone number, an office, or access to our offices. He is, however, a minority shareholder in the public holding company that sits many levels on top of Fund 9, which is making the investment in the Venetian. He's not a limited partner in Fund 9 and has no managerial capacity or any other authority over Fund 9 whatsoever. And he will have no equity interest whatsoever in this Venetian investment. And further, as outlined in the structure, which Sonia Vermez is going to talk about a little bit later on in the presentation, he will have no role whatsoever in managing or overseeing Fund 9's investment in the Venetian. As you know from the structure, which we'll walk through a little bit later, I have the sole and complete control over our firm's investment in the Venetian as the sole member and manager of AIF 9 Pioneer Voco LLC, and also as further confirmed in the non-interference letter that has been furnished to you as part of this process. All that being said, I understand this is a matter of great sensitivity, and I would imagine you might have some questions that you would like to ask myself or any of the folks in the room. So I'd like to pause at this moment to see if you have any questions or comments on this matter.
Sir, if you wouldn't mind, did you intend to go through the rights, certain rights as a minority stockholder that you have in your materials? Just
I can, yes, if you'd like.
please.
So Mr. Black does have certain rights as a minority shareholder of AGM, and I'd like to walk through what those are. It has been disclosed both publicly and of course to you as part of the investigation that he does have the right to nominate someone, including himself, to the Apollo Global Management Board. This is the board of directors that manages the public company that's traded on the New York Stock Exchange. That board currently has 18 board members, and it's a fully independent board of directors. He has informed Apollo, however, that he does not intend to nominate himself or exercise this right. He also hasn't given Apollo any indication that he intends to nominate anyone else to the AGM board, as it is his right to do as well. And we understand that any other person that Mr. Black were to nominate to the board must be reasonably acceptable to Apollo's nominating and governance committee and the Apollo board itself. And those members are bound by their fiduciary duties to the shareholders of the corporation. And any nominee to the board, of course, whether it's him or someone else, would also be subject to a full stockholder vote as per the bylaws and per the rules of the New York Stock Exchange. And then finally, the last bullet point, as discussed in the last meeting, but just to reaffirm it again, we do understand that Nevada has plenary authority to request that any nominee be called forward for licensure, as is your right under your broad powers.
So thank you for that. At this time, yeah, questions have been welcomed. So at this time, Commissioner.
I appreciate it. Thank you, Madam Chair. Thank you, Mr. Samber, for appearing. I hope it's not 3 a.m. wherever you are. The issue regarding Mr. Black is sensitive, and I appreciate you bringing it to the forefront. And I'm struggling within our 15C structure to find the appropriate way to potentially reach back and ensure that we have some oversight or at least review opportunity should things change, because there are some ongoing matters that concern. I think days before the hearing, before the Gaming Control Board, Mr. Black filed suit against Mr. Harris, right? And he's an ongoing member of your board of directors and a co-founder of Apollo. And knowing what happens in litigation, I worry about what that could lead to. I worry about just sort of his outsized potential influence over ongoing employees at Apollo based on historical relationships and a variety of things. He did answer, however, one of my questions was whether or not he was a limited partner or personally, individually invested in Fund 9. The answer to that was no, correct?
Correct.
Okay. Is he an investor? Part of the financing includes the $100 million in revolving credit line. Is he an investor in any of those funds that is providing that credit line?
He's not, sir. And the credit lines being provided by Fund 9, which is the investor in the equity of the Venetian.
They're all out of 9 as well. Okay.
Correct.
Then, I mean, just to not to put you on the, well, I guess to put you on the spot. I mean, when was the last time you spoke with Mr. Black or emailed with him or had a text exchange with him?
Many months ago.
Okay.
Many months ago.
All right. I appreciate that. As I started with, I'm struggling to find the right way to try to use the PIC structure to be able to look back at sort of participants, members, shareholders of a parent company or affiliated entity without calling them forward, because I don't think it would behoove us to ask them to file an application. But I made at the end of this put forward a request that we add another condition that should he change his mind to nominate someone to the board or accept the nomination himself, that there's some reporting requirements affiliated with that. But thank you for your answers. I appreciate it.
Commissioner Cohen?
Thank you, Chair. Mr. Sambor, I want to focus on the Fund 9. And now I'm moving forward in time. You've now done everything you've said that you want to accomplish at the Sands, at the Venetian, under VLVG. Whether you've enhanced earnings, you've made improvements, capital expenditures, and I hate to compare it to any other licensee, such as Cosmopolitan, but they took an asset that was underperforming, and Blackstone sold it for a very large sum of money. Now, I just want to focus on the approvals that you would need internally for you to sell the asset under Fund 9. Now, there was testimony at the Gaming Control Board that basically it stayed within your realm. You didn't have to go to corporate. You didn't have to go up the chain. It would be within the Fund 9 for total ability to dispose of or take public that asset. I just want to reconfirm that is an accurate statement.
100%, yes. No one beyond the fund would be involved in that decision.
And let's take that to the next step. Fund 9 is an independent fund, certainly under the umbrella of Apollo. That you would agree with that? It functions independently?
Oh, yes. Of the holding company? Yes, absolutely.
Yes, sir. Yes, sir.
Yes.
Is there anything that the Apollo would be able to do through shareholder votes, shareholder rights, amendments to charters that could anyway impact Fund 9? Or is Fund 9, on an island far enough outside?
I mean, Apollo could control the governance of Fund 9, I suppose. But again, with regards to this specific investment, I have sole voting control over this specific investment, regardless of what Apollo does.
Very good, sir.
Right, including any decision regarding disposition or anything that goes on at the investment. And I should say as well, they also have agreed to not interfere. So there's the non-interference letter, which further restricts Apollo's rights to direct me with regards to this investment.
Thank you. In fact, I'd like to just briefly touch on the non-interference letter dated as of February 8th. There was a request to go ahead and include Leon Black specifically in that, which you agreed to do through counsel, and your general counsel, Christian Weideman, executed that letter, and I very much appreciate that change. It gives me comfort
that the intent here is to operate within the confines of that fund and not subject to any outside interference. I'll have other questions as we proceed through this presentation, so I'll turn it over to my fellow commissioners.
Thank you, if I may, Chair. Welcome. I wish we could see you in person, but thank you for being here and taking the time. It's very important for you to be here, so thank you again. Just some general questions, for clarity of the record. Is it an accurate statement that Leon Black is still the largest individual shareholder of the Apollo's Class A shares?
I believe he is. I don't, well, you said largest individual shareholder or
Individual, not
meaning
corporate,
like a
just
person
individual.
as opposed to an
Yes, sir.
institution? I
Yes,
think
sir.
he is. I think he
Okay,
is,
and that's my
yes.
understanding as well. And his shares do include voting rights, that's correct?
Yes,
Okay, and Mr. Black has no powers or authority over the management of Apollo's daily operations and is not part of the executive committee, which consists of Mr. Rowan, Mr. Harris, and James Zelcher only, is that correct?
he's not, he has no powers, nor is he part of the executive committee. That's correct.
Okay, and as you sit here today before us, Mr. Black has no significant control position or any kind of power position at Apollo, is that correct?
Correct.
Okay, and based on your understanding, will he have the ability to influence or direct the investment in the Venetian, given his 30 years of control and as a co-founder?
No, he won't.
Okay, and has Mr. Black made any investments directly or indirectly for the purchase of the Venetian resort?
No,
Okay. And Apollo Fund 9, does it have any voting rights as it relates to the Venetian?
no, I do.
Okay. And so you hold the sole voting rights for the Venetian through VoteCo, is that correct?
That is correct.
Right. And then if we could just take a step back, I'm trying to piece together the timeline here for Mr. Black. And I understand he resigned in March of 2021. If you could just explain for posterity's sake how that resignation came about, because I do have some specific questions about that.
About how he resigned?
Yes, how did the resignation come about? I don't know. The record I have before me, and when I watched the board proceedings, it wasn't really clear if there was an internal dialogue in advance of meetings before the resignation. I just need a little bit more context if you could provide that for the record, please.
Sure. I don't know if I mean, I wasn't privy to those deliberations. I wasn't involved. I'm not on the board of Apollo, nor was I involved in discussions with him.
Is there anyone present who can provide me with the information? Thank you.
Yes, good morning, Chair Tagliati and fellow commissioners and Madam Secretary. Brian Carney, for the record, General Counsel of Litigation and Regulation for Apollo. I can tell you and the rest of the commissioners that this was Mr. Black's decision. So I don't know if that's the simplest answer I can give. It was his decision to resign. And that, I believe, is reflected in the public statements that were made both by him and Apollo in the matter.
Okay, I do appreciate that, but I think just to be clear, I'm trying to understand if there was any communication internally before he made that independent decision. And my concern is what kind of safeguards are in place when somebody like a co-founder has very, very serious allegations raised against them. Is it simply his decision? And had he not said something, is there somebody else who would have stepped in? Was there a dialogue? I'm just trying to get background and context in terms of how it came to be ultimately.
Of course. So it would be inaccurate to say that there was no internal communication whatsoever on the issue. As you noted, it's a very serious matter. And of course, there's been internal conversations at Apollo about the matter writ large. However, I think what you're asking is, well, what if he didn't do what he did and made the decision he made? Then would somebody have stepped in? Look, that's a hypothetical, but we didn't have to get to that place because Mr. Black made the decision he did on his own.
And that decision, was that announced before the resignation? I guess I want to take another step back. As I understand, there was Apollo's Conflicts Committee retained Deckard LLP as independent counsel. And was that Mr. Black's idea?
Yes, Mr. Black requested that investigation to happen. It was run by a senior partner at Deckard, independently, had full access to anything he and his team needed. He received all of the information he requested. He's a former federal prosecutor in Southern District of New York. Yeah, it was requested by Mr. Black himself.
Okay, and prior to, I think, the meeting where he made that request that the committee retain independent counsel, was there any internal dialogue about the allegations that were raised, separate and apart from Mr. Black raising this at the meeting?
Yeah, I'm not going to be able to speak to any of those specific conversations that happened. All I can tell you is that, obviously it was determined. Mr. Black asked for the investigation. We thought it was important, and so we agreed to it as well.
And can you tell me who was on the conflicts committee at the time the decision was made to retain Deckard as the independent counsel?
I don't have it off the top of my head. I'm gonna have to get that for you.
Right. I'm just trying to understand what was done separate and apart from Mr. Black. So you have somebody who's an alleged bad actor, and there should be, I think, some safeguards in place forward going, and even at that time. And I'm just trying to understand what they were then, and if there's been any changes internally with the policy or the structure to make sure it's not just Mr. Black who made a decision.
Yes.
Somebody else who can assist somebody who's having serious media attention and bad optics for Apollo.
It's a very good question. Let me address that. So in addition to the Deckard report that was publicly disclosed, there was also another report that was publicly disclosed from the law firm of Wilmer Hale. It set forth a number of, I believe we provided that to the investigators as well, but it set forth a number of, it would be too difficult to exhaustively describe them here, but suffice to say, a comprehensive list of improvements and changes that were important to Apollo from an internal governance perspective, to ensure, broadly speaking, that we are doing the right thing, for lack of a better phrase.
And is there a specific committee in place today to put in place safeguards based on those recommendations that were made by the second report?
Yeah, I think that's going to be the board, writ large, to ensure that, and we are in the process of implementing all of those, but that's going to be a board function to ensure that those suggestions are put in place.
But one thing I'd like to
Please.
sorry to interrupt, I apologize. Subsequent to this entire episode, there were a couple of corporate governance changes that I think are very important to highlight. The first and foremost being that Apollo changed its stock classification to go to a one share, one vote structure. Prior to this episode, I believe the three founders of the firm had additional voting rights beyond just their economic rights. So that's one change. The second is that now Apollo is a fully independent board of directors. So as I mentioned previously, there are 18 people on the board of directors, and insiders constitute a minority of the board. So much like any other public company, Apollo now is managed or overseen by a fully independent board of directors. And the stockholders have more of a say because there's a one share, one vote structure for the stock. So I did think it was important to call that to your attention, because I do think that those changes, in addition to the changes in the Wilmer Hale report, speak to the ability for someone to not resign, I guess, in the face of something like this going forward, which I think would be very difficult, frankly.
Thank you, and I appreciate that. And I was just concerned about the self-policing and the decision of one person who's the target of bad press, so to speak, and just allegations. I understand that nothing's been established, but something in place to ensure that the well-being of the company and the reputation here in Nevada is being safeguarded and protected.
Absolutely, yes. And just one other point to make clear what David said. So before, some of you may remember, way back the Harris transaction and through the Play AGS transaction, that we would repeat over and over again Leon Black, Mark Rowan, and Josh Harris control Apollo. That was and it was also true. That is no longer true. They were the executive committee that controlled Apollo, and that's no longer true. We are now essentially a typical public company, if you will, the Apollo Global Management, the ultimate parent. That was important to us to change the corporate governance such that we fell in line the typical structure as opposed to the historical structure that had 3 people involved. So now, just like any other public company, you have a board of directors, as David said, that is ensuring that we are doing the right thing and is being run like a public company should. And the 1 share, 1 vote also important. Leon, Mark, and Josh do not have the super voting power that they had before. That is now they hold common shares, just like anybody else could who goes to the New York Stock Exchange and purchases shares.
Thank you. And that I just wanted that elucidated for the record, because I think that intrinsic shift is really important. Because, we've heard a lot about Leon Black, but when you have these safeguards in place with the shift in the corporate structure and governance, I think that appeases me. I can't speak for the other commissioners, but that's a concern that I had. And then I got it's like a shorter version. I don't know if it's like 22 pages of the Deckard report. And there was mention about over 20 witnesses being interviewed, with the exception of 1 who was a former employee, and then 60,000 documents reviewed. But I didn't see specifically any reference to, I don't know if I'm pronouncing her name properly, Gazelle Ganeva. And she was, I think, the plaintiff in a complaint that came later in June of 2021. But was she one of the people who was interviewed in the Deckard report? Because I didn't see that in my materials.
I don't believe so. I can confirm that for you. But what I will say, I want to make sure that there are 2 very distinct issues here. One is the Apollo issue with regard to, as you put it, Commissioner Brown, ensuring that we're doing the right thing and safeguarding to make sure that there is no one doing the wrong thing inside our organization. That was the purpose of the Deckard investigation, to ensure that we both investigated the past and could ensure for the future that we're doing the right thing. Now, that's one side. That's the Apollo side. Now let's go to that lawsuit that you just referenced that was brought by Ms. Ganyeva. That does not involve Apollo. Apollo's not a party. As I think there are no allegations against Apollo. That is a personal matter for Mr. Black. And so we aren't involved in that. Again, it's just a personal matter for Mr. Black that Apollo doesn't have a financial or other interest in.
No, understood, but I'm trying to take a step back in terms of the genesis of the need for the Deckard report in the first place. And that related to allegations that involved Mr. Epstein, and Mr. Epstein allegedly had some issues with Ms. Ganyeva that involved Mr. Black, who's involved with Apollo at the time. And so it's intriguing to me to understand whether or not the report would include that relationship and interview her as part of a full and meaningful report to give Apollo a clear picture. Because as I understand, there was an NDA that was signed by Ms. Ganyeva back in 2015. Was Apollo aware of that? Were they involved with that? Was counsel included with that transaction? Can you tell me anything about that?
Yeah, so look, I could probably get the answer before the end of this meeting as to whether Ms. Ganyeva was involved with the investigation or whether she was spoken to. If you just give me, a few minutes, I can get that answer for you before we conclude here.
Sure. And if anybody knew about the NDA that was executed in 2015, if any counsel at Apollo was involved in drafting that, reviewing that, just trying to understand the level and depth of involvement to the extent there is any, because I do see a line of demarcation that's been touted repeatedly. This is Apollo, this is Mr. Black, we had nothing to do with that, that's his private life. But I'm looking at the timeline, I'm just trying to understand for the record, for verification purposes, that there was nobody there that knew what was going on and did nothing.
Look, fair enough. So I will look into that too. Again, if you just give me a few minutes.
Sure.
I will say, however, that the allegations that are made now against Mr. Black.
And solely against Mr. Black. Apollo's not been named. I pulled the complaint.
Yeah. Okay.
Yes.
Okay. So you saw them, and you probably also saw that she amended her complaint to include new things that she didn't seem to recall.
And counterclaims and very long pleadings. I haven't seen things that lengthy in some time.
Exactly. So let me get the answers to your questions, because I understand why you're asking them. And like I said, hopefully we can get that set before we.
Thank you, sir. I appreciate that. And then another question in connection with the Deckard report. It wasn't clear to me whether or not Mr. Epstein's entity, Southern Financial LLC, still owns the shares that it purchased from Apollo back in 2013. I think it's about 263,257 shares. And I think that was part of the initial public offering.
Yes,
There were
and
two different purchases, I believe. It just wasn't clear in the report whether, and I know he's since deceased, but I'm just interested because it wasn't clear from the report that I reviewed. And if I missed it, apologies, but I didn't see it.
yeah, you're asking if any entity that was formerly associated with Mr. Epstein still holds shares in Apollo
Yes,
Wealth
sir.
Management?
And the entity name that I have is Southern Financial LLC.
Yeah, so look, I mean, I will just say this, that I will see if we have knowledge of it. Obviously, as a public company, we don't necessarily know everyone who holds our public shares.
It was just mentioned in the report and there was no finality on that specific point. So I was just interested.
Yep, look, understood. So I will see if we have knowledge of that. Like I said, just because we don't doesn't mean necessarily that it does or it doesn't. We don't necessarily know all of our public
I appreciate that.
shareholders. Yep.
And really, I think you've done with your team an excellent job of explaining the safeguards and changes that have been made since. And the whole concern I had is what influence, if any, could Mr. Black have? Do you have checks and balances in place? And it seems to me that based on the two separate reports that have been obtained by independent counsel, that you don't have a single person who can monomaniacally take over the company and do whatever he or she pleases to injure the company and impact the reputation of a Nevada gaming establishment. So that's really, I just wanted to vet these issues and make sure that I had my answers to give me comfort.
Yeah, I obviously tried to prepare as much as I could. Your questions are very salient, on point, and I understand why you're asking them, so I will get the answers. I do want to just say one more thing generally about your more general concern, and that is, as I told the control board as well, we have it's now, let's see, 15-year relationship with both the state of Nevada, the control board, commission. We have a spotless record, Apollo does, in terms of no fines or violations. Why do we have that? Well, it's not because just luck or happenstance, but rather because we put a lot of work into ensuring compliance at every level. I can tell you that is critically important to us, and it will continue to be, because we view this as a long-term relationship, not a short-term one. And not to mention the potential ripple effects across other companies and industries that we have in regulated industries, SEC, et cetera. So everything we do is with a mind toward ensuring that we are doing what we are supposed to be doing from a compliance and just more broadly ensuring that we are not going to have anybody doing the wrong thing, as you said.
No,
So I wanted to
thank
get some comfort on that.
No, and I saw quite a bit in the materials about Apollo being an excellent community partner in all the different jurisdictions and giving back to the community and involving the employees and taking care of the employees. So I mean, stellar record in terms of the substantial amount that's contributed to giving back and volunteerism and encouraging employees to be part of that. So that is absolutely not lost on me. And so I just wanted to focus on the elephant in the room and get the answers that we need, at least that I need, to move forward.
Absolutely.
And thank you. And that's been done. I appreciate it.
Thank you.
Thank you.
So I don't know who would be appropriate to answer this question, but I would like to know, since Mr. Black's involvement as a manager, member, director, employee, officer of Apollo, any one of those roles, how has his share percentage fluctuated, if at all, over time? So has it always been consistent? Has it been fluctuating? And what is it? I guess what I would want to know is, how has it changed from the time he left March 2021 to now, if at all, and then before?
The last
Well-
question you asked, Chair, go ahead, David.
No, you can answer, Brian. Go for it.
Yeah, I was just saying the last question you asked, and David can obviously weigh in as well, is the easier one, because as you may know, and as I think we went through with the control board, Apollo just undertook a relatively major merger with Athene, and in connection with that, and the governance changes that we mentioned, where we moved to a one share, one vote. So it's a little apples and oranges in terms of pre-merger and post-merger. However, I can tell you, I think one kind of specific data point or two specific data points that I can give you is that now he holds slightly under 12% of the common stock of AGM. That is not what he held before now, because everyone holds common stock of AGM now, right? So he holds slightly under 12% of the common stock of AGM. That was slightly higher, and there was some discussion at the control board hearing about, well, I thought it was 15, I thought it was 12. Either way, it's over 10. But the reason for that drop, and I believe it was in December, was a transfer of interest to some trusts. Again, irrevocable trusts. He's not the trustee. He doesn't hold voting power. The trusts are family vehicles. That is the delta between 12 and 15 round numbers. But Mr. Black himself has control and the vote over 11.9% approximately.
But his ownership, to answer the question, his ownership was diluted in the Athene merger. His ownership prior to the Athene merger was higher.
Right. So okay, that's what I was, that was the
Yes.
second part of my question. Thank you.
Chair, if I may ask a follow-up question based on your question?
Sure.
So the December transfer of the 3.2% interest into the irrevocable trust, I don't believe he has a beneficiary interest in that trust. Is that correct?
Correct. Thank you. I
And
meant
who
to mention
has
that.
the voting rights in that specific irrevocable trust?
It would be the trustees. I'm not sure I have the names at hand. Again, I can get those for you, but it would be the trustees of those trusts and not Mr. It's not Mr. Black.
Understood. And I think as a result of that, and correct me if I'm wrong for the record, the ultimate interest that Mr. Black holds individually is around 11.9%?
Correct.
Okay, thank you.
Yes.
Thank you, Chair, for the indulgence.
I think what we were trying to do is have questions related to Mr. Black at this point. And I'm not sure if there are any others from any of my colleagues. It appears there are no further questions.
I just had one final question about Mr. Black.
Sure.
Do you know if any criminal charges or if there's an investigation that I heard there was an investigation, but then at another point at the board proceedings, I heard that maybe there was an investigation. I don't believe any criminal charges have been lodged against Mr. Black. Just again, trying to do research, trying to understand for clarity of the record. Do you have any information on that?
Yeah, let me address that. I know the report that you're talking about. I forget, it was in a Nevada publication. I can tell again, we don't necessarily know what's going on with any prosecutor office, but I will tell you this: we're not aware of any. Not only are no criminal charges been filed, that is an unequivocal statement. We're not aware of any criminal investigations going on with respect to Mr. Black at any prosecutor's office.
Thank you for clearing the record on that because I heard some inconsistencies and I just wanted one statement for the record. Thank you, sir.
And just because it was mentioned, and I apologize if I missed it, but maybe I'll ask the chair of the board. Did we have the Wilmer report?
I did not see it.
I did not see a Wilmer report.
I received the 22-page Deckard report, but not the other one.
We didn't get the Wilmer report, but it was provided to investigators according to.
So I don't want to get anybody in trouble. Of course, I believe I said that I thought.
So it might not have.
Yeah, I mean, look, it's been obviously a long investigation, and we provided, reams and reams of material, but it's publicly available.
Yes, we know.
Thank you for distilling
We're aware
what
of
we
the
have.
reams, but I don't think the Wilmer report was part of the reams.
Not to us, but notwithstanding that it might have gone to court or somewhere, but I have not seen it personally.
And I just want to, because it was brought up, I just want to make a record that we, the board, have not had an commission have not had an opportunity to review it. So, so is there anything else related to that line of questioning before we move on with the presentation?
Yes, Mr. Carney, you did jump up earlier when I was asking about the suit that Mr. Black had filed against Mr. Harris. And I just wanted to afford you the opportunity to make your state your case on that, if you had something additional to add.
No, it's actually just product of the video with Mr. Sandberg. So more, it's a little easier when we're both in the same room. I didn't know how familiar David was with that suit, so I was just trying to be helpful. But no, there's nothing to add other than what I said before, which is that it's a personal matter, just like the Ganyeva lawsuit. Doesn't involve Apollo. Apollo's not a party. So that was what I was going at.
So thank you for answering all of our questions. I believe you were moving to slide 8. Mr.
Thank
Sandberg.
you. Yep.
Thank you.
Thanks, Brian. So as Brian said, gaming has been a key sector for us from an investing perspective. And I personally have been involved in many of the transactions on this page. It's a sector that we've done quite well in, with one notable exception, which is Caesars, which will be something I'll talk about in a little bit. But shifting to slide 9, this lays out the jurisdictions that we as a firm have been licensed in, and myself, I'm licensed in many of these jurisdictions as well, including, substantial numbers of tribal jurisdictions that would take many pages to lay out. But I think it's important to note that we do take compliance and reputation very, very seriously. And what Brian said, I think, is very important, which is we always try to maintain good relationships with all of our regulatory bodies, whether they be gaming regulators or financial regulators or otherwise. On slide 10, I did want to take a little bit of an opportunity just to talk about Apollo's commitment to leading responsibly and expanding opportunity. I spoke a little bit about this during the Gaming Control Board hearing, but I think it's very important that we get into the record our philosophy around best-in-class corporate governance and ESG. So on the left-hand side of the page, we have been a long-term leader in ESG in the private equity industry. And you could see some highlights. We were named one of America's most responsible companies in 2021 and 2022 by Newsweek. Our portfolio companies have contributed over $1 billion in donations to charities in the aggregate. And we've hired most recently a woman named Carletta Uden, who's the global head of ESG for our private equity business. That's going to be working with all of our portfolio companies, including the Venetian, post the ownership period, to put in place strategies regarding ESG. We've announced most recently 2 initiatives. The first is a fairly significant across-the-board reduction in emissions in our portfolio. We've committed to a 15% reduction in emissions across the portfolio. And the second, which I'll talk about a little bit later, is a fairly large commitment to purchase goods and services from diverse suppliers. And then on the right-hand side of the page, just speaking a little bit more about expanding opportunity, at Apollo, we've done a lot of work to expand our talent pools at the portfolio company level. We operate 2 proprietary networks for talent, one called HBCUNet, which gives us access to talent from historically Black colleges, and then the Veterans Network, which allows our portfolio companies to hire veterans. Again, these are proprietary job boards that are run by our portfolio company, Career Builder, on behalf of Apollo portfolio companies. We have several affinity networks internally. I am personally the chair of our Pride Network, which is our LGBTQ plus equality group. We received a 100% score on the Human Rights Campaign's 2022 Corporate Equality Index. And then on the bottom of the page, I thought it was important just to talk about board representation, which is another effort that I've been championing with my fellow colleagues. So it's been very important for us to increase board diversity. And I'm pleased to say that 35% of all U.S. portfolio company board members are underrepresented minorities, and every one of our boards has at least one woman and one racial ethnic minority. And though the board of the Venetian is not seated yet, and obviously anyone that's placed on the board will be subject to approval, it is our anticipation that 5 of the board members of the Venetian will be women, and several of them will be racial and ethnic minorities. We did sign the NASDAQ Board Diversity Pledge, and we are the only signer that I'm aware of that was in compliance with the NASDAQ Board Diversity Pledge on the day that we signed it. And then I'll talk about our supplier diversity initiative in a second. So slide 11 talks about a little bit more of our citizenship highlights. These are programs that are done at Apollo, not for portfolio companies. So employees of the firm, as you can see here, this is in the last year, have committed over 5,700 hours to volunteer causes. We've given citizenship grants to over almost 1,500 nonprofits. We had a competition internally for funds, and 86 people participated with pitches for this competition. And you could see that people are engaged in over 30 offices in 11 countries in these efforts. And slide 12 gives a little bit more detail on some of these efforts across Apollo, from volunteerism to donations, to heritage and awareness events, and then food drives as well. I did want to talk on page 13 about this supplier diversity initiative because it happened subsequent to the Gaming Control Board hearing, and it's something we're very proud of. So on February 7th, 2022, we announced that we were going to commit $1 billion per annum of spend by 2024 from our portfolio companies to diverse suppliers. We think that this is the biggest pledge that's been made by any private equity firm to date. This supplier diversity initiative is going to advance our mission of expanding opportunity and uplifting diverse-owned businesses in our communities. The Venetian, as a portfolio company of Apollo, will be a participant in this program, and we're looking forward to the Venetian improving the amount of spend that it places with diverse suppliers. So we're very excited about this initiative. As part of this, Apollo also joined the National Minority Supplier Development Council and the Women's Business Enterprise National Council as board members, and we're going to help them as well as they'll help us to facilitate relationships with qualified diverse suppliers. So we're very excited about this initiative. On slide 14, just a review of the team. So Frank talked about myself and Monta, who's in attendance. You heard about Brian earlier. And now I would like, on slide 16, to talk a little bit about Caesars, and of course, give you the opportunity to ask any questions you might have about that as well. So this was another topic of discussion during the Gaming Control Board, and I thought it would make sense to give you a little bit of the background on the Caesars investment and what happened there. So first on slide 16, just to rewind the tape, we signed the transaction to buy Caesars in December of 2006. And from the time we signed the transaction to when it closed in January of 2008, basically all of the underlying conditions that were assumed in the transaction completely reversed themselves. So over that ensuing time period, the stock market completely crashed at the onset of the great financial crisis. Unemployment went from the low 4s up to above 10%. And what began was a multi-year period of declines in Clark County gaming revenue, and indeed gaming revenue across the entire United States. And I think in particular for that recession, I'm sure folks remember travel to Las Vegas in particular was somewhat vilified by folks in the government. So it really was a tremendous negative confluence of events that we were faced with between signing the deal and closing the deal. And if you look on slide 17, our backs were basically immediately to the wall. And at that time, as you might remember, there were several other gaming transactions that were done. So Penn National had agreed to be bought, and that transaction ultimately didn't wind up going through, and the people that had agreed to buy it paid quite a large settlement. Over that time period, Station Resorts went bankrupt, and several other casino businesses were on the verge of bankruptcy, including actually Las Vegas Sands, who got a significant infusion of capital from Mr. Adelson. You can see, though, on slide 17, that despite the capital structure challenges that we were faced with as owners of Caesars during this terrible time, we did sponsor significant investments that the company made nationwide and in Las Vegas. So I'm personally very proud of the substantial improvements in assets that the business undertook over this time period. Things like the renovation of the Imperial Palace into the Link and the building of the retail dining and entertainment district, which is now called the Link, and the Ferris wheel, the acquisition of Planet Hollywood, changing the Barbary Coast to the Cromwell and building the club on top, the quad, and then substantial improvements to Caesar's Palace, such as the renovation of the Roman and Augustus Towers and the completion of the Octavius Tower and the rebranding of the Nobu Hotel. We did all these things because we knew the only way for the business to grow into its capital structure was to grow. And in the face of declining gaming revenue, we thought that capital-led investment that would produce a return would grow the profitability and the cash flow of the business. But sadly, it wasn't enough. And as has well been discussed, the business ultimately was not able to grow back into its capital structures, despite the best efforts of us and the management team and other constituents for many years. And Caesars Entertainment Operating Company did decide to file for bankruptcy. That's one of the 3 subsidiaries of Caesars. And it was a very long, protracted, and quite arduous bankruptcy. And what I would like to talk about next is on slide 19, and then I'll stop for questions. One of the questions we get asked is, why won't this happen again? And I really could not think of 2 polar opposite transactions. Yes, they are Italian-themed casino resorts in Las Vegas, so there is a similarity. But really, everything is completely different for this transaction versus the Caesars transaction, most notably the capital structure and the timing of the transaction. So the Caesars transaction was struck literally at the top of the market, whereas the Venetian transaction was struck pretty much at the bottom of the market. And the benefit in doing that is that the capital structure designed for the Venetian transaction took into account the very low level of earnings and cash flow that the property was generating during the heights of COVID when the transaction was signed. And in fact, we designed the capital structure to allow the business to operate during significantly long periods of time under very arduous conditions. The Venetian will have only $18 million of interest expense. And as I'll walk through in a little bit, that interest could actually be picked. So it could be accrued and not paid in cash. Whereas Caesars had over $2 billion of cash interest obligations. And as you can see, the cash interest obligations for Caesars were 60% of the company's annual earnings, whereas with the Venetian, it's about 5%. And then finally, I'd be remiss if I didn't say that we have accrued 15 years of additional experience after this, substantial experience in the gaming sector, and it's all been very positive. We owned Aliante in North Las Vegas. We've owned Play AGS, which is a slot manufacturer. We own Lottomatica in Italy. We owned Gala Coral in the UK. And all of those investments were very successful investments. And we've taken that experience and also the experience at Caesars and learned from it quite a bit. I'm sure you might have questions. I wanted to take this opportunity to pause here and answer any questions that you might have.
Well, just as a point, we go through a lot of, I understand that all applicants have to answer this. It has to be somewhat frustrating to go before the board and then come to the commission, and some of the questions are the same and some of them are different. But for the record, we each like to have a complete record of what we considered before we place our vote. And for myself, I will say that that there were some answers to some of the, that each of us, I know, have reviewed all the hearing in front of the board. And at that hearing, you went through the points that were learned. I believe, I can't recall which board member asked you to literally list the points. And I found that very helpful. And I don't have any additional questions because, to use a judicial phrase, I'm going to incorporate those answers herein by reference. Anybody else on the panel have? Oh, go ahead, I'll wait.
Thank you very much. I appreciate it, Madam Chair. I do have questions about what happened with Caesars and the. I've tried to dig in as much as possible to understand what happened there, and obviously the market conditions at the time were not favorable, to put it mildly. And I'm sure as you were closing, you were gritting your teeth, right, for what was about to come. But decisions that were then made subsequent to the closing and sort of doing what you, I think, felt probably was necessary to generate the operating capital to keep things floating were decisions that were made, and I have a hard time evaluating them. But others who have evaluated them have suggested that some of those decisions were made to prop up the parent company and the value of Apollo's interest in the parent company rather than the ongoing operations of the OPCO that was transferring out certain properties or things like that. Particularly Richard Davis in his examiner's report for the bankruptcy. And I've read some responses to that by Mr. Rowan, but I'd be curious for your take.
Sure. So all of the efforts that were undertook really were in the name of extending the runway of the business. What I mean by extending the runway is increasing its liquidity, increasing its maturity window, and getting more compliance with financial covenants. Yes, to the transfers that were undertook at the time were reviewed and structured by very well reputed legal counsel. And they were all done in the name of providing capital to the business to allow it to continue to operate and deleverage. Of course, if the business were to continue to operate and deleverage, it would be beneficial to the equity. So I think we had an aligned interest in the business prospering, but it wasn't done to specifically enrich the equity holders at the expense of the assets in the business. Because there, to the best of my knowledge, there really would have been no way for us to make an equity return if the business didn't deleverage. And that was what every transaction was designed to do, which was to get capital into the business and to allow it to deleverage.
I think and the reason that I'm asking, right, is I think it gets to a question of priority for you as the sole member of the VoteGo, and how you would make decisions going forward for Venetian property. During the board hearing, we heard a really somewhat touching anecdote from, I think it was Mr. Goldstein, relating to Mr. Adelson and coming to him to make a proposal about whether or not to pay the employees once of the Venetian and the Sands once the pandemic hit. And Mr. Adelson leaned over to him and patted him and said, "Just pay them." And I wonder whether you can make that same decision as you're looking out for both your equity investors as representative of Apollo, but also the person who's ultimately in charge of the property and doing what's best for the property more holistically. And so how do you weigh those varying interests?
Yeah. So look, I can't put myself into Mr. Adelson's shoes and understand, what was guiding his decisions. But I don't think as an owner, I would necessarily have different motivations than he would to do whatever's best for the property overall. So I think that I would act in the best interest of the property, which indirectly is in the best interest for us as the owner. And I think as we've gone through this deck, being good corporate citizens and doing right for employees and doing right for the communities in which your businesses operate is good business. I think that's only been more established over the last 15 years.
And one of the final things I wanted to ask about was, it was well documented at the time, back in 15, 16, or whatever, regarding the following the Chapter 11 filing, that the CERP payments to certain retirees canceled. I believe that there was a representation at a later board or commission meeting that Caesars made good on those obligations permanently. But if you could, I'm not sure whether that was the case or not. I haven't been able to verify that. But was there a way in your mind that could have been avoided? Would there potentially have been a structuring issue that could have been done to avoid having those people's those individual employees' retirement payments cut off upon the filing of Chapter 11?
Yeah, so unfortunately, it was a heavily negotiated item during the bankruptcy, and it's not atypical, unfortunately, for creditors who are secured to negotiate hard against those types of retirement benefits, which are unsecured. But in this case, like it happens in most cases, we were able to negotiate to get those benefits paid.
I'm thinking more about proactively. Would there have been a way to avoid it, or in the future, is there a way to avoid something like that?
In what sense, sir?
Well, and I guess it's very, again, it would be accepting something that's probably unlikely. If you were to end up, if you were in the same situation again, right, would there be a way to avoid having sort of those individual creditors hurt rather than, while fights go on with Oak Tree and Appaloosa and whoever?
I suppose it could have been part of the original restructuring term sheet. The problem is that 2/3 of the creditors didn't sign on to the restructuring term sheet, so it wouldn't have been binding.
Yeah, I appreciate it. I just, from an individual perspective, those are the stories we try to avoid, right? Where our employees.
100%. I think it was very important to us, right? And it was very important to us for many reasons to make sure that those retirees got paid, which is why, as a condition to the final deal, we were the ones that insisted that it was taken care of.
I'll stop there for now, Madam Chair.
Commissioner Cohen, I know has something brief.
Yes, thank you, Chair. I am truly convinced that what we're looking at today is a different scenario than what you addressed in the Caesars. In fact, I'm not even going to ask any questions what happened back then, because I know that, the answers are the answers, and it's been fully vetted, it's been fully litigated. But I do want to say that while anything can happen based upon scenarios, in the world or the United States, what you're going into, as you stated, with the different interest rates, with the capital structure, with the lease that obligates you to certain capital expenditures, I just see as a different animal, and I'm perfectly satisfied. As you put it, a repeat would be an incredible, unlucky situation, actually for the world, if that were to happen. So anyway, with that, I'll turn it over to any other colleagues who have a question, and we can move on.
Thank you so much for that presentation on that component. And I really do see a huge distinction between what occurred at Caesars at $2 billion of the cash interest expense. And there's nothing of the sort here. It's so diametrically opposed. We have 18 million of cash interest expense, and the timing is so different. I mean, you're getting it here at the bottom of the market. The interest rates were quite impressive. For me, represent a lot of lenders, and we get, stuck in bankruptcy sometimes. So the 1.5% interest rate between now and 2023 and the 4.5% through maturity is just well negotiated. And I think it's important to note that there are no financial covenants here for the seller financing from the Venetian. So that can often, when you have a non-monetary default, trip up the borrower. So we don't have that here. So I am simply not concerned. I think there are different interpretations about what happened in bankruptcy, what motivated bankruptcy, what was done in the interest of employees versus the Apollo company ultimately. But I am very comfortable that this will not be an issue. And to the extent there will be issues financially, that you have safeguards in place, not only with the interest rate, but no financial covenants. And I don't have any questions specifically. So I wanted to commend you on negotiating such a great interest rate. And I think the timing is just different. Thank you.
Thank you.
So if there are no other questions, did you want to resume your presentation?
I will, yes.
Thank you.
So what I'd like to do for the remainder of the presentation is talk about the Venetian and what our plans are for it. And then legal counsel will come up and talk about our licensing structure. And then, of course, we'll answer any other questions that you might have. So slide 21. So the Venetian really is, I think, one of the most iconic resorts in not only Las Vegas, but really in the United States of America. As you know, on March 3rd of 2021, we signed a deal to buy the Venetian, the Palazzo, and the Sands Expo Center from Las Vegas Sands. for $6.25 billion. And then simultaneously, the real estate was sold for $4 billion to Vici. And then the property will lease back the right to use that real estate under a long-term lease. And the Venetian really is, again, an irreplaceable, iconic asset. Over 7,000 hotel rooms, 2.3 million square feet of convention space, casino facilities, really the first MICE-based integrated resort in Las Vegas, a credit to the founder of Las Vegas Sands, Mr. Adelson, and an irreplaceable physical infrastructure. And when we got the call that they were interested in selling it, despite the fact that it was in the middle of COVID and financing the transaction would be difficult, I really did believe this was a once in a lifetime opportunity to buy an amazing asset. So I'd like to talk to you on page 22 about what our investment thesis was for the property and what we anticipate doing with it under our ownership period. So first and foremost, as I mentioned, it really is an iconic and irreplaceable marquee asset. Largest hotel resort in the US, replacement cost significantly in excess of what we paid for it, large convention center, and then the Sphere that's going to be built in the back of the property. But I really did believe this was a once in a lifetime opportunity. If there's any property that deserved to be purchased, it would be this. At the time we bought it, it was during the heights of COVID and the business was losing a substantial amount of money. And part of our investment thesis, which I think has now come to fruition already much quicker than we anticipated, was a recovery in the business. So the business has recovered quite quicker than we had expected. The business reported numbers in the fourth quarter that are quite positive. The convention business is not completely back, but overall the financial performance of the business is run rating in excess of 2019 levels and certainly doing much better than the money losing position it was in March of 2021. And we think the real opportunity is revenue enhancement and performance improvement. So working with the management team led by George, we, through our due diligence, identified numerous opportunities to improve the property. Some of them are going to require capital, some won't. I think there's an opportunity in entertainment, and I'll go through that a little bit later. F&B offerings, potentially the opportunity to grow the room base, and certainly an opportunity to renovate the rooms over our ownership period. And then we see some other further opportunities beyond just the organic strategy, like potentially M&A, potentially getting the property into online gaming, which should be some incremental opportunity. And then through our prior experience with Caesars, I think we're big believers in loyalty and customer relationship marketing opportunities. And we think that there are upsides there as well. So on slide 23, I'd like to talk a little bit more about the capital structure because I think it's very important to cover it. So as has been discussed, the property will have $1.2 billion of debt, which is 3.4 times pro forma 2019 EBITDA after the lease. And if you look on the bottom left, we've shown based on our projections how the business deleverages. And I believe that this level of leverage is probably amongst the lowest of any casino buyout that's been done in recent history. But not only is the leverage low, but the interest coverage is even higher. So interest coverage is the ratio of the EBITDA of the property to the interest expense. And given the fact that the interest is at first at LIBOR plus 150 and then steps up over time, the business out of the box has almost 20 times as much earnings as interest expense. And that low level of interest expense will allow the property to generate a significant amount of free cash flow with which to pay down debt and to reinvest in the property. On slide 24, I'd like to talk a little bit more about the capital structure. So I mentioned the low interest expense. In addition to the low rate of interest, we do have the option to accrue interest payments, it's called PIK, onto the balance sheet through the end of 2024. Rather than paying cash, it was very important to negotiate that ability because, again, at the time that the deal was struck, the property was losing money. It was negative cash flow. So it was very important to us to minimize as much as possible the fixed charges on the property. The debt has no maintenance covenants. So unlike other traditional bank loans that are placed with third parties, and again, I suppose I should remind you that the holder of the debt is going to be Las Vegas Sands Corporation. There are no maintenance covenants, which means that there's substantial flexibility in that If earnings go down for whatever reason, we're not subject to quarterly monitoring, and there's nothing that could cause a default under the debt other than the non-payment of interest or the payments of the debt off at maturity. And then we talked about the lease guarantee, or it was mentioned earlier, but Las Vegas Sands has also agreed to guarantee the lease payments that the property makes to Vici through the end of 2023, which again provides further cushion for the business should cash flow dip, which we have no expectation of will, now that the property is recovered so quickly. So I'll stop there, see if you have any other questions on the capital structure. And if not, I will ask Ms. Church Vermees to step forward and talk about the licensing structure.
I did have some questions just going back to the volunteering and the community partnership. Is now a good time, or do you want me to wait and reserve that until the end?
You do it now.
Okay, great. And so I was looking at the Club Corp entity, and as I understand, it's the largest owner operator of the private clubs globally. Do you know if any of the golf and country clubs are owned or operated by Club Corp, have a discrimination clause, or have a history of barring membership to anyone based on race, color, gender, or religion?
They definitively do not discriminate based on race, gender, or religion.
Okay, good. I just wanted that for clarity of the record. And then, are there any statistics available on the performance of the HBCU net educational recruiting platforms? I understand they're new and there might not be a lot of data points, but is there any data that you've gleaned so far from the program being launched?
I could follow up with the data if you'd like, and I don't know off the top of my head, but we've hired a significant number of veterans, for example, and we also have hired a significant number of candidates through the HBCU net. I just don't have the numbers at the top of my head.
Thank you so much. I have no further questions about those two.
Ms. Vermees? Oh, I'm so sorry.
Thank you, Madam Chair. Mr. Samber, our report from our staff indicates that as you entered into the negotiation, I think it's on. Can you hear me, Mr. Samber?
I hear you. Yes, sir.
Okay, sorry. Our report indicates that Goldman, which had been hired as the banker, had made the recommendation to partner with a REIT instead of taking the property on entirely yourself. Was there a reason in particular for that, to go with a REIT structure for the real estate?
It says, I mean, I don't think it matters whose idea it was, but I do think it was my idea. The simple reason is that we knew Las Vegas Sands wanted over $6 billion, and it was a time in the market where there was no financing available. So we were trying to figure out how could we put together a way to pay them the $6 billion. In this case, it was $6.25 billion that they wanted to sell the property. So given that there was no traditional debt financing available, we came up with the idea to sell the real estate and then lease it back to Vici. So we approached them, they were interested, but they were unwilling to enter into that lease because the property had negative EBITDA at that point in time. So they had questions about the property's ability to service the lease until earnings recovered, which is what gave genesis to the lease guarantee.
All right. Well, I didn't want to give credit where it wasn't due. I apologize. But
no worries.
You know, in some ways, it's interesting. It comes full circle, right? Vici was spun out of Caesars, and here we are cutting them back in on this one. So I appreciate that. Thank you.
Yep.
Ms. Vermees?
Good morning, Madam Chair, members of the Commission, Madam Secretary. For the record, Sonia Vermees, shareholder with the law firm Brownstein Hyatt Barber Schreck. At the board meeting, I went into great detail about the licensing structure and the waivers that we'd requested, and also the statutory and regulatory support for that. It was clearly the driest part of the presentation. I believe Member Katsouris said that his eyes glazed over. So I'm not going to go into that excruciating detail today. I think that we have a very full record based on the presentation, what you have in your materials, what's in the agenda. So I'll try to highlight what's most important. The first step of the transaction, as you heard, was the transfer of the operating assets of the Venetian to a new entity, Venetian Las Vegas Gaming LLC. You have a transfer of interest application before you. That's one of the last steps, and that is for that entity, the member's interest in that entity to be acquired by Pioneer OpCo LLC. The ultimate ownership and management of Venetian Las Vegas Gaming LLC is being effectuated pursuant to Commission Regulation 15C, which sets forth the licensing requirements for a private investment company. You have in your materials, I believe on page 26, structure chart, and you'll see there is a blue rectangle in the center, Pioneer Topco LP. That is the private investment company. The aggregator of over 90% of the economic interests in that entity is the limited partner shown in the red right rectangle on the right of the chart, AP9 Pioneer Holdings LP. 100% of the voting securities of Pioneer Topco LP are held directly by its sole general partner, Pioneer Topco GP LLC, which in turn is owned 100% by sole member AP9 Pioneer VoteCo LLC, which, as we've discussed previously, it has a single managing member, David Samber. In addition to AP9 Pioneer Holdings LP, there are two additional limited partners holding the economic interests, Pioneer Management Holdings LLC and Pioneer Management Co-Invest Holdings LLC. Pioneer Management Holdings LLC was created to implement the equity incentive plan and provides for equity awards that management, board members, and key executives are granted as part of their compensation. And then there's also Pioneer Management Co-Invest Holdings LLC, which was created to give the opportunity to selected members of senior management, consultants, and members of the board to make an investment in the Venetian alongside the Apollo funds by purchasing equity in Pioneer Management Co-Invest Holdings. The limited partner interests in Pioneer Topco LP held by these two additional entities reduce the limited partner interest that's held by AP9 Pioneer Holdings LP to less than 100%. So one of the waivers requested is a modification of the characteristics in Reg 15C that 100% of the economic securities are held directly or indirectly by one or more private investment funds. At closing, we expect AP9 Pioneer Holdings LP to hold approximately 98% plus, as the investors in the co-invest entity will indirectly hold less than 2%, and no options or restricted equivalent units will have been exercised. We've also requested two additional waivers or exemptions as set forth in the agenda, which relate to the fact that the ownership of the options, restricted equivalent units, and units in these two LPs may fluctuate, and we wanted to allow for flexibility coupled with the appropriate regulatory notifications. Regulation 15C210 requires administrative approval for dispositions of any direct interests of any economic securities in private investment companies, which would impact the ability of these entities to adjust their ownership percentages in the private investment company when they issue actual units or should employees exercise their options or restricted equivalent units. However, Regulation 15C400 allows the Commission to exempt a person, a security, a transaction, or any portion thereof from the application of Regulation 15C or any portion thereof. Based on the proposed conditions which we've reviewed and are acceptable, Pioneer Topco LP would still have the obligation to report any changes, and the board and the commission always retain the right to call forward any option, restricted equivalent unit holder or unit holder forward for suitability. In addition to the entities discussed, there are various intermediary companies that have requested approval or registration. And lastly, Pioneer Holdco LLC has requested approval to pledge its members' interest in Pioneer OpCo LLC, and Pioneer OpCo LLC has requested approval to pledge its members' interest in Venetian Las Vegas Gaming LLC, to Las Vegas Sands Corp. In connection with the seller loan, and to the Apollo entity in connection with the revolving credit agreement. Unless you have any questions regarding any of these matters, I was going to hand it back over to Mr. Carney to discuss some additional items on compliance.
If I may, just briefly for
Yes.
clarification purposes, so I'm trying to understand the key distinction between the features relating to the employee co-investment vehicles, and I'm talking about Pioneer Management Holdings LLC and Pioneer Management Co-Invest LLC.
Yes.
And as I understand, Co-Invest is not open to employees. Is that correct?
No, it's executive, so
Okay,
yes,
it's only selected members of senior management consultants and board members, correct?
correct.
Okay, and then the other distinguishing feature is that co-invest is not subject to vesting. Is that
That's
accurate?
correct. They
Okay,
buy their interest directly.
okay, thank you. I had no further questions.
Anyone else?
I had
Oh,
one,
sorry,
que-
yes.
thank you, thank you, Mr. Mays. I had one, I'm just trying to understand the purpose of Midco. Is it for the aggregation of assets that may then not be pledged under the seller financing agreement? Is that,
That's correct.
Okay.
If you consider that Pioneer Opco is a borrower and Holdco is a guarantor, Midco is a clean entity in there that gives the company flexibility should they want to do something with that in the
Thank you.
future.
appreciate it.
Thank you.
Good morning again, Brian Carney, for the record. So before I get into compliance, and I will, I just wanted to address specifically some direct answers to your questions from before that I was able to get.
Thank you.
But before I even do that, I wanted to just address the Wilmer Hale report. For anybody who's interested, I of course have a copy, but electronically. But it was linked to in our press release, January 25th of 2021. There was also an SEC filing the day prior where it's referred to. So it's publicly available, as I said before, and anybody who wants a copy, I'm of course able to provide that. And like I said, important to us that we implement those suggestions that were made in the Wilmer Hale report. Okay, so
Thank
to your
you for that.
questions.
Yep.
Of course, and to your questions, Commissioner Brown. So first, you referred to an entity that was associated with Mr. Epstein. I can tell you, subject to my caveat before, that we're a publicly traded company, that we can't possibly know everybody who holds our shares. We are not aware of any entity affiliated with Mr. Epstein who currently holds shares in AGM, our parent company. That's first. Second, you also asked whether Ms. Ganyeva was part of the Deckard investigation or interviewed. I think you specifically asked.
Correct.
The answer is no. I'll also just note from a timeline perspective that her lawsuit came months after that report was issued.
Quite some time after.
Quite
But I
some.
didn't know if the NDA, based on the 60,000 documents, was something that might have been a trigger to include her.
I totally understand why you asked. And so let me address the NDA too. I can tell you also that Apollo's lawyers were not involved in that at all. And that was Mr. Black and his personal.
Thank you for clarifying that. I think it's important.
I
appreciate
totally
it.
agree, and thank you for giving me the opportunity. Okay, so let me move now to just compliance. We touched on some of this before. You know, there are two buckets to this: Venetian compliance and Apollo compliance. Venetian compliance, of course, very important to us for all the reasons we talked about before. We've submitted a what we think is a best-in-class plan to the GCB, and they're considering that. We understand. And we're keeping the current compliance officer, Mr. Richardson, at Venetian. We're adding Patty Becker as the chair of the compliance committee. I believe she's well known to everyone. So from a Venetian perspective, that I think both gives an indication of consistency and hopefully, you know, some enhancement to ensure that we have a best-in-class compliance system at the Venetian. Second bucket is Apollo compliance. So that would be what are commonly referred to as AML KYC procedures, looking at investors who come into our funds, ensuring that they are not objectionable people for all the reasons I discussed before. Once you let somebody in under the tent like that as an investor who is a questionable individual or entity, you blow your entire reputation. So we take it very seriously. And as I think mentioned before, we're of course regulated by SEC, FINRA, FCA in the UK. So we have plenty of regulators that are helpfully looking over our shoulder to ensure we are indeed doing the right thing. And I think I touched on the other points about, you know, our track record in Nevada before, so I won't belabor those, but we'll pause if anybody has questions.
I have none.
But both are welcome.
Good answer.
All right, thank you.
Thank you.
Thanks. So I'd like to talk a little bit more just about the go forward operating plan for the property and then leave any time for further questions you might have. So I'm on slide 33 of the presentation. So to remind you, our role will be owner and board members. I'll be on the board of directors, and as you know, I'll be the sole voting shareholder of the Venetian. It's our intention to leave the management team that's currently running the property in place, led by George Marcantonis, who you ruled on earlier. He'll be the president and COO of the property post-closing, just like he is pre-closing. And we've listed on slide 33 the other members of the management team that our expectation is will remain with the property. Robert Brimmer, who's there in the room with you, who I could see half of his face on the Zoom, will be taking over as the CFO post-closing. I believe that he's also up for licensing with you at a later date. Rob worked at Caesars in a variety of senior finance positions, and we're very excited to have him join the property. So on slide 34, I don't feel like I need to review this again, but it speaks to just the quality of the assets of the property that we will be lucky enough to be owning post the transaction should it be approved. And on slide 35, I'd like to talk a little bit more about the value creation plan. So I spoke about the post-COVID recovery. I think it's important to talk about some of these revenue and other optimization opportunities. So in consultation with George and through our due diligence exercise, we are excited about some opportunities to enhance the revenue and profitability of the property, most notably in entertainment, where they had 4 theaters that were closed pre-COVID. And we think there's opportunities to improve the property's entertainment footprint, enhancements to food and beverage, and then, of course, the opening of the MSG Sphere, which will open in 2023, and I think will drive substantial traffic and revenues to the property around their shows. And then I do think that there are some interesting capital improvement opportunities. So one of the benefits of a transaction like this, whenever we buy an asset out of a larger corporate parent, is that we're solely focused on maximizing the equity value of just this asset. So our investment solely in the Venetian, and our aim is to solely increase the value of the Venetian. And what that means is that the property has to compete only with itself for capital. So all of the various potential capital opportunities in the property will be amalgamated and reviewed by Rob and George and the rest of the team. And then we will help them decide where to allocate capital. That's a little bit different than the way it worked historically, where the Venetian had to compete for capital dollars with other properties that were part of Las Vegas Sands, and it may or may not have been a strategic or may not have produced the same returns as some of their other alternatives. I do think with that difference in philosophy, there are going to be incremental opportunities to deploy capital at the property to make a positive return. We're very excited about that. We've listed some of them on the page. That could be new gaming facilities and new gaming experiences. I talked about entertainment, enhancements to the convention space, which I think are possible, renovations of rooms, and then the potential for even new room product as well, either at the tower on the Strip or elsewhere on the property. So we're pretty excited about that. And that's a process that is going to start in earnest post the closing of the acquisition. If you have any questions there before I go to the next slide. Okay.
Yes,
Turning the wrong.
just briefly. Can you talk to me a little about the Palazzo condos?
You're talking about the St.
Status of
Regis
that?
Tower?
Yes,
You're talking about the half-finished hotel tower?
that's correct. As I understood, it was the target date for completion was 2010, and I think Starwood was involved. Is it still involved? What's happening with that? If you have any information about your plans?
No.
Okay,
Starwood doesn't exist. Starwood's part of Marriott now.
I know. I
So
lost
yeah.
good points. I'm not happy about it.
Yeah, so the
They're
tower,
worthless now.
yeah. So the tower is draped, and as part of our due diligence, we looked at the cost to complete on a rudimentary basis. We didn't undertake a very detailed analysis. I do think that there is the potential for more rooms on the property, especially to support the convention business when it comes back. So we are going to undertake a more detailed study about whether it would be best to place those rooms in that tower and complete it, or to put them elsewhere at the property.
Thank you for clarifying that. And then I don't know if this is implicit or if there's an express limitation placed upon VLVG in terms of market representation in Asian countries. I saw specific identification of Japan as a place where there might be some efforts to bring people to Las Vegas, but is there any express limitation, or is that misunderstanding on my part?
I'm not aware of anything in Japan. As part of the deal, Las Vegas Sands retained their operations abroad, including marketing operations. So we did not assume those as part of the transaction.
Understood. I just saw Japan identified as one of the potential places in the future to try to get more attention and more marketing to come to Las Vegas. And I didn't know if there was an express limitation. There was a carve out, or if you were open and available to go to any place in Asia.
You're saying, are we prohibited from marketing in Japan, for example?
Precisely. No. Are you, is Japan one of the carve outs where you're allowed to market? And is there any carve out for any places where you're prohibited from marketing under the agreement?
It's a good
It
question.
was inferred. I just wanted to be clear, because Japan was specifically identified.
Did we identify Japan?
It was in the materials.
Was it?
It's okay if you know. It's not. I
I'll
was just curious.
I'll have to get back to you. I apologize. There
No worries at all.
are limitations because we're licensing the Venetian name from Las Vegas Sands. So as per that licensing agreement, there are some limitations on our ability to use the brand and the marks to market the property in certain jurisdictions abroad. I just don't remember offhand where Japan falls into that.
Thank you. That was my understanding as well. I have no further questions.
All right, so there's no.
So on slide
questions.
36, just one part. Yeah, go on. Sorry about that.
No, we're good. Go ahead. Thank you.
Okay. So I wanted to just wrap up and talk a little bit more about how I anticipate myself and my colleagues who are on the board will interact with the property. So as board members, representatives of Apollo will be a sounding board for the executive management team, and our job will be to help shape strategic direction for the company and also act as an owner. And I will be the representative for Apollo, as we've discussed, as the sole voting member of Pioneer Topco LLC. The management team is going to run the business. We're not an operating company. I think I've made that clear. The model of private equity is to own various businesses and push the authority to run those businesses into the actual operating businesses. And then the boards of directors of those businesses monitor the operations that the management team leads. We do think that we are particularly good at building businesses and providing capital support. And for the things that I've talked about today, like potentially new rooms or renovating spaces in the property, we are hopeful that our experience as allocators of capital will benefit the property and Las Vegas and also benefit our investment. We are experts in capital markets. I think in this situation, it probably won't matter very much, given the very attractive financing that I don't think anyone on earth can improve upon. So we're very pleased with the financing structure of the transaction. We do provide access to our global network of financing relationships, our portfolio companies. I talked about the supplier diversity initiative. I think there's an opportunity for our portfolio companies to become potential clients of the Venetian, particularly on the convention side. So we're excited about that. And then we are going to help the management team to the extent that there are acquisition opportunities that may come about in the future. And then on slide 37, I just wanted to sum up. And really, again, thank you for hearing from me and for all the questions that you've asked us as part of this inquiry. I wanted to apologize again for not being able to be there in person. Trust me when I tell you, I would have loved nothing more than to be there in Nevada with you rather than sitting in this hotel room halfway around the world, separated from you all, and then seeing my family later tonight. So I apologize for that, but hopefully at some point in the future, I'll have the opportunity to appear in front of the commission again to answer any questions you might have that come up. I did want to summarize with our commitment to the property and say that we do take this responsibility seriously. Again, it's not lost on me that we are putting our reputation at the forefront in this transaction. We take it very seriously. I know the press talks about the parallel between this and the Venetian, and it was a very high profile transaction that didn't go well, but it really is the exception rather than the rule. In my history at Apollo, that is the biggest negative transaction result that I've seen. And we really do pride ourselves on making sure that our businesses do well. We lever our businesses less than peers, and that is the exception rather than the rule. I'd like to say that, we're committed to all the stakeholders, whether it's the commissioners, whether it's the local community, whether it's the employees of the property. And we're looking forward to supporting the management team and making sure that the property continues to be a leader in Las Vegas. And I think the property has been a leader in Las Vegas, sponsoring various initiatives to combat hunger, homelessness, improve education outcomes. And we're looking forward to building upon all of those and making sure that this is a property that is left in better shape post our ownership period than when we found it, which I think is quite a tall order, because to the credit of Las Vegas Sands, they've done an amazing job being community leaders. So that concludes my presentation, and I'd like to welcome any further questions you might have.
All right, at this time, my colleagues have any additional questions or comments?
I have comments, but I don't know if he's making another.
No, I was just coming up. I thought,
Oh.
ready for a motion.
No, I just,
So I have nothing to say.
well, thank you for coming to the podium.
He's been ready for a long time.
He's like, another question from Commissioner Brown. Stop. Just my personal take, if we're discussing anything at this point, I don't have any other questions. I see 30 years of systematically and methodically improving the value of companies through capital investments and capital allocations and performance improvements here. And I do view Caesars as an anomaly, and I don't, so to speak, hold it against you. I understand that it was a different time. And I personally have no areas of concern. I thought the presentation today was very meaningful, thoughtful. I appreciate you going back and getting answers and taking all of our concerns seriously. And it means a lot to us, and it means a lot to me personally. And I am absolutely prepared to support the application that's presented to us. I thought the presentation was very polished. I appreciated the cheat sheet here. I mean, we've gone through the binders and we've watched the presentation and reviewed the transcripts before the board, but this was just an excellent presentation and not fluff. It was like real data, very helpful information, and very succinct and easy to follow. So thank you all for taking the inquiry seriously and bringing us the information that we need in a very easy, digestible format. I'm very hopeful that Apollo will be and continue to be a community partner here that's well received in Nevada. And I'm very excited to see what Apollo will do while it grows and improves. The Venetian, big shoes to fill, of course, but I have no areas of concern at all.
Thank you, Chair. I'd just like to state for the record that this is a pretty comprehensive record between what the board has put out, what this commission has brought out today. I'm entirely comfortable with moving forward because I do think that good cause has been shown. The applicants in totality have met their burden under seeking the waivers under regulation 15C.010A and 15C.210. To the extent we went into the periphery regarding extraneous is the wrong word because they're not extraneous, but issues outside of this purview of licensing, I do think we're covered going forward under the purview of regulation 15.090, which gives the commission, and ultimately the board and other statutes, plenary authority at any time should any of the non-interference issues become breached. So there's plenty of reasons to move forward on this application today. And with that, I'll turn it back over.
Commissioner Kikep.
Thank you, Madam Chair. Appreciate it. As I look forward, I was sort of looking for parallels, right, between the Caesars experience and what we face here. And I look at our economic challenges and the uncertainty over a pandemic and interest rates and whatever the economy is going to bring us that we can't predict at this time. And I think almost no matter what happens, the scenario that we're walking into or that Apollo is walking into here is just so vastly different based on the financing that's in place. I mean, just the debt load is they're worlds apart. And in a worst case scenario, I mean, what happens, right? The Sands takes back over the Venetian and the Palazzo. I mean, that's there's just no real comparable outlook that would make them parallel. So, so that concern just sort of doesn't exist for me based on the transaction itself. As it relates to Mr. Black, I do have ongoing concerns, even with all of the structures that we have in place, that based on who he is and his experience and his time, that he's able to potentially have, if not control, influence. And I don't know how to settle that within the 15C structure. I don't know if there is a way, really. But you know, we have the non-interference letter that he's specifically mentioned in, and we have the other structures in place. I would potentially like to suggest that we add a condition that if there is to the vote go, that if he does decide to exercise his right to nominate someone to the board, or that he himself is nominated or is appointed, that simply a report back, come back to the Gaming Control Board and the commission, so that it ends up on our laps. We have to have the opportunity to review that. And I mean, knowing that we could always call him forward at any time, but I think it's a statement that if something changes in his posture, that we'll be notified. But otherwise, I believe that the goal of Apollo to increase the value and profitability of the Las Vegas Sands properties, the Venetian and the Palazzo, is good for our city, good for our state, and I'm here to support it.
Before I ask Commissioner Keycapper a question, I'll say this. I'm not going to repeat everything that's been said by my colleagues here. I'll simply say that, you know, in addition to echoing those comments and agreeing with them, I've lived here since 1978. I don't know any of personally any of the team that's going to remain in management. However, I know of their reputations. They're very well respected in our community, just generally, and in our gaming community. So I applaud you for, you know, keeping that management team and putting so much value on the employees that have, you know, made the Venetian a great property. And I would ask Commissioner Keycapper, did I hear a motion with a condition of notification? Is that what that?
Yeah, I'd be ready to make a motion,
I
Madam
have
Chair.
a
I believe that
question
there was an
about the condition.
additional,
Oh, 1 second. There's a question about the condition from Commissioner Brown.
Commissioner Keycapper, the condition, as I understood from you, is that if Mr. Black nominates someone or himself to the board, that we must be notified within X days. Is that correct? Because I see a distinction between someone that's not him versus him. So I'm trying to understand the basis for the someone nomination.
right. Well, I think that he's posturing that he's going to be hands off. And if that changes, then I think we should be notified. That's all.
No, I wanted to parse if it's a third party that he's nominating versus himself, or do you just want notification if it's himself?
I think all of the above.
Okay, and then is it necessary, is it already required under the regulations that any change in the composition of the board is brought to us anyway? I just want to make sure it's not superfluous.
Not of Apollo, I don't believe. I mean,
No.
we're not regulating
Okay.
Apollo.
All right.
And then I believe that there was another amendment to one of the conditions that the applicant wanted to make. Is that accurate, or has that been?
Yes, it was a minor addition and I had submitted it and discussed it with Deputy Chief Tigio. So I think you have the language and it should be fine.
Yeah, I do. I have the language and I'll read that into the record.
Thank you.
Thanks.
And does Apollo have any objection to that condition? I'm just curious.
No, we do not.
Thank you.
All right, Madam Chair, thank you. I appreciate it. And I'm going to keep it brief, but I would move to approve that The commission approve non-restricted item number 2 as recommended by the Gaming Control Board and read into the record by Madam Secretary with an additional condition that applies to AP9 Pioneer Vote Co. LLC that it will immediately notify the Nevada Gaming Control Board and Nevada Gaming Commission should Leon Black nominate an individual or be nominate an individual to the Apollo Global Management Inc. Board or be nominated, appointed, and or elected himself to the directors. And that we make the change to the first condition that applies to Pioneer Topco LP so that it will now read that Pioneer Topco LP will only issue options and restricted equivalent units to current and prospective employees, executives, and managers of Pioneer Topco GP LLC, Pioneer Topco LP, and their subsidiaries or estate planning vehicles established for any such individual's benefit.
I believe that's the language that was submitted, correct?
Yes.
Okay. Is there any discussion on the motion? There being no discussion on the motion, all in favor of the motion, say aye.
Aye.
Any opposed? No. Congratulations.
Madam Chair, thank you and thank the commission. And I would like to make one statement. Commissioner Cohen mentioned the very thorough and complete report on a complicated matter that you received. That's greatly due to the hard work of the corporate securities team and the investigations team that worked with Apollo throughout this whole process. They did a wonderful and a professional job. Thank you.
Thank you.
Thank you, Mr. Chair.
Thanks a lot.
Thank you.
You're the boss. Do you need? Because we're gonna, I do. Okay, we're going to take a very, what do you need, like 5-minute break? Thank you. When you're ready. Are we ready to go? Okay, I've got the thumbs up instead of the. Madam Secretary, please read in non-restricted number 3. Sorry. Please read in non-restricted number 3, Madam Secretary.
Non-restricted number 3 is the application of Las Vegas Sands Corp. For deregistration as a publicly traded corporation. The recommendation of the Gaming Control Board is for approval. I believe we have disclosures or recusals on this item.
Thank you, Madam Chair. Consistent with my previous disclosures, NRS 281A 420 requires me to disclose that on this matter, I am an employee of the law firm McDonald Carano. The law firm performs some legal work, non-gaming and not related to this matter for the Las Vegas Sands Corp. I have no interest in the application that's before us today. It does not affect me personally. I had no previous knowledge about it. I conclude that the independence of judgment of a reasonable person in my situation would not be materially affected by this relationship. And therefore, I'm prepared to participate in vote today.
Thank you, Chair. I would also reiterate my disclosure with respect to non-restricted item number 1. I and my firm represented Las Vegas Sand entities in unrelated litigation having nothing to do with gaming that concluded years ago. I have no pecuniary interest in the item before us, and I don't believe the independence or judgment of a reasonable person in my situation would be affected by this prior representation, and therefore I intend to participate in deliberation and voting.
Any other disclosures? There being none, thank you.
Good afternoon, Chair Tagliati, Commissioners. For the record, I'm Mark Clayton on behalf of Las Vegas Sands Corporation. Upon the closing of the transaction that you approved in item number 2, Las Vegas Sands Corporation will no longer be subject to the jurisdiction of the Nevada Gaming Control Act. So therefore, it's appropriate as an administrative matter to deregister Las Vegas Sands Corporation. We reviewed draft number 1 of the order terminating registration and believe it's in proper form.
Okay. Any questions? There being no questions, do you? I'm sorry.
I don't have any questions. I just wanted to take a moment and thank the Adelson family and Mr. Adelson. Obviously, he's no longer with us, but his family made a huge commitment to this town. I mean, it's changed the face of it and is a almost lifelong Nevada. And I really appreciate all the contributions they brought to our community. A lot of them were not publicized, and he just always did the right things for the right reasons. And I wanted to take a moment to thank him.
Thank you, Commissioner Salazar. On behalf of the Adelson family and the company as a whole, we appreciate those comments, and I'll make sure personally that the Adelson family gets a copy of the transcript, so she'll see those remarks.
If I may, just I have a fond memory of Mr. Adelson, who came to visit us at the Boyd School of Law, which was at Paradise Elementary. So we had a sandbox and girls and boys bathrooms. And he came with his wife and what we call the men in black security guards. And we were so impressed that he would take the time out to come to a brand new law school and to visit very impressionable law students and spend time with us and impart wisdom. So I think that just tells you the kind of person he is and the legacy that he's left behind. And I will never forget that. And I think, well, obviously he will be missed, but the family, we send our condolences and thank you for the large footprint that they've brought to the state of Nevada.
Thank you, Commissioner Brown.
So before I entertain a motion, have you had an opportunity to look at the order terminating registration, and is it, and there's not much to it, but I assume you're okay with it?
Yeah, we believe the draft number 1 of the order is in proper form, and we support the board's recommendation. Would ask for the commission's approval of that order.
Thank you. At this time, do we have a motion?
I move for approval of non-restricted agenda item number 3 and provide the chair with authority to execute draft number 1 dated 1/11/22.
Any discussion on the motion? There being none, all in favor say aye.
Aye.
And it appears there are none opposed. Thank you.
Thank you.
Thank you.
Madam Secretary, please read in non-restricted number 5.
Non-restricted number 5 are the applications of Victoria Holdings Limited for transfer of interest, the registration of Belgrava Invest AB as a holding company, and Tristan Nee Soberg and Michael Bertel Knudsen for funding of suitability as a director and shareholder. The recommendation of the Gaming Control Board is for approval. I believe we have a recusal on this item.
Thank you, Madam Chair, Madam Secretary. Again, pursuant to NRS 281A 420, I would like to disclose that I'm an employee of the law firm McDonald Carano. The applicant in this matter is represented by Mr. Gutwald, who is a partner in that firm. And based on this pre-existing relationship between me and the firm, I feel that this presents a conflict of interest and I should recuse myself on this matter. Thank you.
Thank you. Any other disclosures or recusals? There being none.
Good morning, Dennis Gutwell with the law firm of McDonald Carano. This is a pretty basic transfer of interest application. I wanted to thank the commission for waiving appearances of the applicants. The foreign travel would have been pretty difficult at this point in time. Control will stay the same as it was before. This reorganization is simply for tax purposes. And I think with that, I'll open it up for any questions.
Does anybody have any questions? All right, there being no questions, this appears proper for a motion.
Thank you, Chair. I move for approval of non-restricted item number 5 is read into the record by Madam Secretary and recommended by the Gaming Control Board.
Any discussion on the motion? There being none, all in favor, say aye.
Aye.
And there are none opposed, and the record should reflect Commissioner Keycapper did not vote on this item. I think I should also, I was remiss in noting that Commissioner Solis Rainey did not deliberate or vote or place a vote on non-restricted item number 2.
Good enough. You guys have a good day.
Thank you. Right, Madam Secretary, please read in non-restricted number 6.
Non-restricted number 6 is the application of Zen Sports Inc. doing business as the Book at Baldini's, doing business at Baldini Sports Casino for a waiver of Nevada Gaming Commission Regulation 4.080 as noted on the agenda. The recommendation of the Gaming Control Board is for approval with the condition as also noted on the agenda. I believe we have a recusal on this item.
Thank you. Yes, Louis Roca, the firm where I'm a partner, represents the applicant, and I therefore must recuse myself from voting on this matter.
Anyone else have a recusal or disclosure? There being none. Hi, could you state your appearance?
Good afternoon, Chair Togliatti, members of the Commission. For the record, my name is Glenn Light with the law firm Louis Roca, and I should be joined virtually by the applicant, or the president of the applicant, Mark Thomas. Hopefully he joins soon, but in any event, to begin, thank you for allowing Mr. Thomas to appear via Zoom. And just as a brief recap, in August of 2021, Zen received several licenses to allow it to operate the Big Wheel Casino and Baldini's. To date, we have activated all of those licenses with the exception of the sportsbook license, which is just pending approval of the sportsbook platform. We are working diligently on that. We just received all of the necessary approvals from the independent test lab, and now we are going to be providing those reports to the technology division so that they can make a final review and determination. So ultimately, we hope to start operating sports very soon, and certainly within the 6-month time window that this waiver would afford us. I do see Mark there on the Zoom, so if you have any questions for Mr. Thomas, please.
So I had the opportunity, obviously, to observe the board meeting. I appreciated the answers of your clients to the questions of the members of the board, and I don't have any additional questions.
If I may, I just had a quick follow-up with respect to compliance. What's your compliance situation like? I know when we were here in August of last year, you didn't have a designated or dedicated compliance person, but you indicated that's something that was going to be, on top priority.
Yep.
Once you actually got going with operations. So if you could maybe just give us an update on that, that'd be great.
Absolutely. So in the interim, Mr. Kowalski, who is the general manager, is overseeing compliance. As Mark can attest, they are now actively searching for a compliance officer. That does take some time, but that is one of their top priorities. At the moment, they are I guess the fact that we're not operating sports at this moment has allowed us to take this cautious baby step approach We've taken over the casino, which has 6 employees, working very closely with the licensed slot route operator there, who is, helping with the management of the day-to-day operations. And so, it wasn't like we had to operate a casino and sportsbook at the same time. But Mr. Thomas can certainly give you an update on where they stand with hiring a compliance officer.
If you would, please.
Correct. So we took over the Big Wheel. Correct. So we took over the Big Wheel Casino October 26th. So we've been operating that for almost 4 months. As I talked about during the board hearing, I think we've accomplished a lot there in the first 90 to 120 days in terms of, taking care of the employees, adding additional slot machines, remodeling the casino, adding additional TVs, all that kind of good stuff. And while we haven't yet launched the sportsbook there, we have begun already the search for both the chief compliance officer for the company at the corporate level, as well as a compliance director specifically for Nevada. In the interim, Robert, as promised, has been handling that. As I mentioned during the board review, we have had daily touch bases with Strategic Gaming, which is the slot route operator and prior owner over at Big Wheel Casino. As you can see from our history over the last 3.5 months since taking over Big Wheel, we have filed everything on time. We have paid everything on time in terms of all our taxes, all of our filings. In fact, we actually got something corrected that wasn't taken care of for us. We were able to get that fixed. We've really been on top of it. So that's really, I think, a testament to the fact that we, care very much about this place. We're adding a lot of TLC to it that matters to us. And now BMM, the Independent Test Lab, has issued us the certification for our technology. And as of this past Monday, February 14th, we submitted our technology for final review to the tech division at NGCB. And we're expecting final approval next month. And we will then be launching at Big Wheel. And with the hopeful approval of the extension at Baldini's a few weeks after that.
Okay, perfect. So just for clarity, then right now they're operating the Big Wheel, but they still don't have any operations at Baldini since the sports book has not opened. Is that correct?
You are correct.
Okay, thank you. I don't have any other questions. Thank you.
Anything else? All right, there being no additional questions, it would appear this is proper form for a motion.
I'd move for approval of non-restricted number 5 is set forth in the Gaming Control Board. I'm sorry, non-restricted 6 is set forth in the Gaming Control Board's recommendation.
Any discussion on the motion? There being none, all in favor, say aye. Aye. There are none opposed, and the record should reflect Commissioner Brown recused and did not participate on the vote on this item. Thank you very much for your appearance. Thank you, sir.
Thank you.
Thank you.
Thank you.
Thank you.
Madam Secretary, I believe that brings us to our restricted items held out for discussion. Please read in restricted number 1.
Restricted number 1 is the application of Gurinder Kohli for temporary licensure as personal representative, administrator of the estate of Kohli Singh Kohli. Is also the applications of Quickie Mart Inc. for a transfer of interest and Gurinder Kohli for licensure as a director. The recommendation of the Gaming Control Board is for approval. I believe we have appearances from Carson City.
Hello.
Hello, good afternoon, Chair Tagliati, Commissioners, Madam Secretary. For the record, Sean McGinnis with Butler Snow on behalf of the Quickie Mart. To my right is Gurinder Kohli. She is the President, Secretary, and Treasurer of the Quickie Mart Inc. entity. To my left is her son, Gagandeep Kohli. And if I could just sort of frame this as to why this item was held out and where things stand, we did go through and do a record of the board, but I think I can summarize it pretty succinctly to sort of help us move along. Gurinder's husband, unfortunately, passed away a year ago, January. And what happened is she did not follow the regulation to properly notify the board within the time frame set forth in Reg 9. And it was only when she was dealing with her estate attorney counsel that they brought in gaming counsel, which is when I got involved in May of last year. And then we made the notification to Chief Douglas. We then coordinated with Barry Chilton and investigations to do an application for her to be the personal representative for the shares and to also transfer them to herself. That's what this agenda item is. as well as to add her as a director of the entity. Another issue that came up is that during the course of this pending period of time, one of her sons was interfacing with the bank, and the bank was asking for some clarifications in the Secretary of State filings, and there were some erroneous Secretary of State filings made without involving counsel that we did subsequently have to correct, and we corrected those at the end of last year. And those items are totally correct to show that Gurinder is the only officer of the entity. And the ultimate goal here is they have signed a space lease agreement with the slot route operator that they have, Century Gaming, and Century will be coming forward as a applicant to become a space lease licensee for this location at a later date, because what Gurinder wants to do ultimately is to transfer ownership of this to her sons. And so that's sort of where we are, and we're here to answer any questions you may have.
Thank you. I'll open it up to my colleagues.
Thank you. Just a quick follow-up. First of all, Ms. Coley, condolences on the loss of your husband. But I just wanted to obtain clarification from both of you on the record that you are aware that any future changes would require gaming approval before you undertake them.
Correct. We're aware of this. Correct.
Yeah.
Correct.
Yeah.
Okay.
They both-
Thank you. I mean, I understand the circumstances, but it is important that you be mindful that going forward, we would obviously expect more of you, given that you had this slip up now. We do expect that you're going to be mindful of the regulations and take the proper steps to get things improved before you actually make any changes.
Right, and just for the record, I have had a discussion with them that once this moves to the space lease agreement, that before there could be any transfer to her sons as the gaming rights holder, there would have to be notification of a change of the landlord entity, which was what Quickie Mart Inc. would be. So we have discussed that to make sure that that's abundantly clear.
Thank you very much, Mr. Guinness. I appreciate that. And I have no other questions. Thank you.
If I may briefly, thank you both for coming. Welcome. Again, my condolences as well on the passing of your husband, Mrs. Cole. I did have a question about your actual review of the regulation 9.020. If you've had an opportunity to review that and you understand what the issue is and the changes that were made to the Secretary of State filings and the implications, have you actually had an opportunity to review that with counsel?
Well, we've spoken about it. It's like that she missed the period of time. She missed it by like 90 days before she could notify the commission and the board, and she should have made application for this within 30 days. And we did discuss that. Yeah.
I asked that you actually print a copy of the specific regulation so that if she has any questions for you, she can understand exactly what the issues were and what the requirements were in terms of immediacy.
Okay.
And so that she can understand forward going. I don't think this will be an issue again. And to the extent there are any changes, you need to, of course, retain counsel and or simply bring the information by way of an application so that we don't have any issues. Is that understood, Ms. Coley?
Yeah.
Yeah, and I'll make a copy of that for them and make sure that they have it in the file.
I appreciate that. I think we can maybe just sit with them and go over it.
Yep.
So that they can never say they haven't seen it. That would be helpful for at least for our purposes here today.
It makes sense. Yeah.
Thank you. And I'm prepared to move forward with the motion unless anybody has any questions. Okay. Chair Tagliati, I move for approval of restricted item number 1 as recommended by the Gaming Control Board and as read into the record by Madam Secretary.
Any discussion on the motion? There being none, all in favor say aye.
Aye.
All right. Thank you. It's been approved and there's none opposed.
Okay. Thank you very much.
Thank you.
Thank you.
All right, Madam Secretary, I believe that brings us to restricted number 2.
Restricted number 2 are the applications of KC Arena Inc. for a transfer of interest and Brian Anthony for licensure and officer, director, and shareholder. The recommendation of the Gaming Control Board is for approval.
Good afternoon. I'm Keith Redman. I am the transferor. And I'm Brian Anthony. I'm the transferee.
Okay, thank you for waiting and being here for your matter to be heard. Um, Did you have an intention to kind of give us an introduction of yourselves, or?
Actually, no, my attorney was supposed to be here. I think he's on his way, but I'm kind of new at this as we speak.
It's just screaming into the hearing room.
Okay, well, we're here.
Dave Crosby, I apologize. We told him to call me when it looked like there's about 45 minutes left and I miscalculated.
It's okay.
Your timing's perfect.
Okay, so so we called the case. We were inquiring as to whether you had an affirmative presentation or comments you wish to make before we open it
I
up to
just say
questions.
that Mr. Anthony's been at this location for 24 years. He's now decided to take an equity position in the business and well qualified. We have dealt with all the questions raised by the Gaming Control Board. We feel that he'll make an excellent co-owner of this location.
Thank you. Do any of my colleagues have any questions?
If I could just have Mr. Anthony just step forward, please, and describe for the record what happened in terms of disclosure versus oversight, or should I say non-disclosure versus oversight? If you can just in your own words explain to us.
Absolutely. I originally applied, I believe, back in 2019, and at that time I had no violations at all. I did receive a DUI in 2019. I disclosed it to the Board of Realtors, which I have a license with, 10 days late. I didn't even realize that I was 10 days late. 2 years later, they then disciplined me for being 10 days late. So that's why on that application that it's not marked that I had any disciplinary action on my professional license, because at the time I did not. And I didn't realize that I had to amend my application, or I certainly would have.
So it was an inadvertent omission. It was not an intentional failure to disclose. Is that your testimony today, sir?
Yes.
Well, it sounds very exciting. I just have to say, you've been the fabric of the bar for 24 years, and it seems like a dream of yours.
It is, absolutely. Yep.
And I don't want to stand in your way, but notwithstanding that, you have disclosure obligations. So I just want to make sure that you have had a chance to confer with counsel and that you understand your obligations going forward to the extent there are any other issues that you might have to bring to light.
I completely understand, and there are no any other issues.
Okay, thank you, sir.
And looking forward to the future. If there were any, we will make full disclosure in a timely manner.
Thank you.
Any other comments or questions? All right, there being no additional comments or questions, does anyone have a motion?
Just one last thing.
Okay.
So in connection with your gaming application, it's my understanding you did not disclose the DUI in any way, shape, or form. Is that correct?
There was no DUI when I applied, and then afterwards I didn't realize I had to explain for the gaming application. And then in April of 2021 is when I got disciplined from the real estate board, and I didn't realize I had to amend that to you guys.
Did you have counsel at the time you applied for the gaming application?
I believe so, yes.
And did you disclose the DUI to your counsel in connection with your gaming application?
No,
Okay, and
because
counsel
I didn't have a DUI, ma'am, when I first applied
initially.
And then I did not disclose it to Mr. Crosby. I didn't feel it that they went together. I didn't realize it at all.
We did disclose it to the Liquor and Gaming Licensing Board, and they were aware of it and have considered it. I don't know why it wasn't disclosed to the Gaming Control Board. I thought that it had been, but I don't recall that far back. I remember yesterday pretty well.
Understood. I have no further reservations with the caveat that disclosure is very important and this is a privileged license.
I understand.
And it appears you do understand that. And I saw in your own words, your understanding of that. So I have no reservations.
I just had a follow-up question, Mr. Crosby. You indicated you did you disclosed that to the liquor board. What was the timing of that? Because Mr. Anthony just testified that he hadn't disclosed it to you. So I'm just a little confused on the timing.
He hadn't disclosed it to me prior to getting the DUI. It's
No, I understand that. I mean,
But
he,
after he got the DUI, he disclosed it to me. I was aware of it after it happened. He was quite concerned. And we struggled through it for some time. But in terms of dates or timing, I just don't recall. He was immediately concerned about it and we made disclosure. I had thought we'd done it with the Gaming Control Board, but
okay.
and I still think if I have some notes that might refresh my memory, we may have disclosed it to the Gaming Control Board. I just do not recall.
Okay. Well, the record doesn't indicate that it was disclosed, so I just wanted to understand the timing. You know, I think our agents do a very good job following up and, you know, probably would have identified it. If it'd been disclosed, they wouldn't have indicated differently. So, again, I mean, I don't want to beat a dead horse. You know, you've worked very hard for this. I mean, I hope you appreciate that. You know, alcohol seems to have been a problem with, in other instances, you know, some are far removed, but this one's closer in time. So I would just urge you to be mindful of that and of course, make immediate disclosure should you have any other incidents, whether they be alcohol related or not.
Absolutely, I understand.
I do have one observation. Your saving grace, for me anyway, is the fact that you did make the disclosure to the Arizona Department of Real Estate. I know you did it in 20 days versus 10, but you actually made an affirmative disclosure. It wasn't something that you waited for somebody to find out about. So it seems to me that there was a confusion in your mind about the timing of disclosure, the necessity, because you did it to one regulatory agency, but not for the Gaming Control Board. So that's, to me, your saving grace.
Thank you.
And some of that may have been council's fault and not the applicant's fault. I just don't recall.
Understood, and thank you for making that affirmative statement.
My only comment, Mr. Anthony, is when in doubt, contact your counsel, Mr. Crosby.
Absolutely.
Any other comments or questions? There being none? Does someone have a motion?
Sure, I'm prepared to make a motion for approval of restricted item number 2 as recommended by the Gaming Control Board and is read into the record by Madam Secretary.
Any discussion? There being none, all in favor, say aye.
Aye.
Any opposed? There are none opposed. Thank you.
Thank you.
Thank you very
Good luck
much.
and congratulations.
Thank you kindly.
Madam Secretary, please read in our next agenda item.
Next for your consideration is a gaming employee registration appeal regarding Cynthia Meza Guzman, as noted on your agenda.
Ms. Meza Guzman, do you wish to step forward, please?
Afternoon.
Hi, could you speak into the microphone and state your name for the record?
My name is Cynthia Meza Guzman.
Okay, Ms. Guzman, I think, you know, you are aware of generally the procedure because you're here. I will tell you before we start that the rules and the procedure of this require us to contain ourselves to the record below, meaning whatever is part of that record is all that we're going to consider. So just so that you know what we're referring to, there was a recommendation before the Nevada Gaming Control Board signed by Dr. Brittany Watkins, a member of the board. There's a transcript of a hearing before the Gaming Control Hearing Officer Winterton, and you had at that time Ryan Helmick as your counsel, right? We have a transcript of that. We also have notices that you received that, you know, brings you to this point.
Yes.
Right? And then we have a register of actions from the Las Vegas Justice Court. We have a declaration of warrant and summons that was part of your criminal case. We have your pretrial services walkthrough paperwork. And that's pretty much what we're relying on, right? To make a decision related to your appeals. So now is the opportunity for you to be heard. And then if there are any questions that my colleagues have, we'll ask them.
Okay. I'm just gonna read really quick what I typed and then.
Okay, you got to speak up because I can't hear a thing.
Okay, I'm just gonna read what I typed and then.
That's fine.
I have made some significant poor decisions that have led me here today. During this case, I was unaware of the details of the warrants associated with my case. I have acknowledged my wrongdoing and I'm currently in the process to correct and bring some peace to those I affected. I can stand here today and say that I'm not where I want to be, but I'm learning and I'm trying. I understand it's a privilege to work in the gaming industry. I ask you all for another chance to have the opportunity to again work in the industry. I've been working for the industry for over 10 years and I'm just asking for a second chance. And thank you.
Okay, so I have a question for you. Okay. Do you remember Agent Winterton testifying at that hearing?
Yes.
Okay. And we have a transcript of that. And at that hearing, on page 5 of the transcript, it says, when I spoke to Ms. Meza on Monday, September 20th, 2021, she stated she was currently employed at Resorts World as a bartender. I asked Meza about being arrested for the domestic battery. She stated nothing happened, period. I explained to her I had the police report and she was obviously arrested. Meza stated I was never arrested. Meza stated she had court for the incident on September 22nd, which was continued to the 26th of October 2021. She insisted she was never arrested and nothing happened. I asked her how she got a court date if nothing happened, and her response was my attorney. I don't want to talk about it anymore. And at that point, I ended the conversation. Do you remember that testimony of Agent Winterton?
I do remember. And I told him I wasn't arrested because technically I wasn't arrested. The incident that happened at that time, actually I wasn't not aware of a warrant. I wasn't aware of anything. I mean, I was at that point I knew I had a warrant and I had my lawyer specifically. We were going through do the walkthrough, but before that I never got arrested because the incident happened. And
okay, so this is the point I want to get to though.
Mhm.
Okay, because I didn't actually get to the question yet.
Yeah,
So that was a
sorry.
lot of information, but
Sorry.
just catch a breath, right? Because we're just going to have questions and answers. And then at the end of the questioning, if you have anything you want to add, I promise you will let you. Okay.
Okay.
Okay. So my question is, do you remember that testimony?
Yes.
Okay. And then you were represented by an attorney, Mr. Helmick, at the hearing.
Yes.
And there's nothing in this transcript that disputes what this agent said. Is that right?
Okay.
Meaning you didn't get up at the hearing and say something else. No, that's not true. He didn't ask me that. I didn't do that, right? Correct?
No.
Okay. And so when you told him that nothing happened and he was talking to you on September 20th, you had a walkthrough, meaning you physically went to justice court, correct?
Yes.
Okay, so you went to justice court on August 25th. You stood before a judge.
Mhm.
Yes?
Yes.
All right. They handed you a complaint,
Yes.
a piece of paper like this that
Yes.
charged you with a felony, right? Yes?
Yes.
And they asked you to read it.
Yes.
And your lawyer probably said, we waived the reading, meaning the judge didn't read it out loud to you, right?
Yes.
Okay. And then you had to enter a plea. Do you recall that?
Yes.
Okay. And then you were handed paperwork because your lawyer asked for an OR.
Yes.
What does OR mean to you? Did you post bail?
I had to pay. Yeah. I mean, I did the walkthrough and
Okay.
then
Where did you go for the walkthrough?
Downtown.
Yeah. What building did you go to?
So I went to the justice court first for the
Right. Then they gave you a piece of paper and
Yes.
you walked somewhere. Do you remember where you walked?
Yeah, across the street
To the jail?
To the jail.
Yeah,
Yes.
it's not a place you forget.
No.
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 Even just the smell. You don't
No.
forget that. No.
No. I
Nope.
was there for a long time.
Right. So you were arraigned, you entered a plea, you got paperwork, you went over to the jail. Did they fingerprint you?
Yes.
Okay. Do you understand why I'm asking you these questions?
No.
Because you told Agent Winterton about 35 days later, nothing happened. That's what you told him, and I wasn't arrested. But you had been to court, you'd been given a paperwork with a felony, you'd entered a plea, right?
all that happened after he called me.
Okay.
He
So
called me
if I
on,
have a justice court record that says that you had an initial appearance on August 25th, 2021 as part of the record, I'll let you look at it if you like. Do we have an officer that can show her this? Look at this. Right here. That says you were present in court on that day with Ryan Helmick. You entered a plea, you got OR paperwork, and that's how you keep from going like in handcuffs. Is you
Yeah.
get the paperwork and you go over and you don't have to post bail, correct?
correct.
Okay. So do you dispute that court record there?
No, all this is true.
Okay.
But the thing is that when the officer called me, I didn't know anything. I knew everything after this. He called me on, I think it was a Monday, and I did my walkthrough on Wednesday. So that's when I found out everything about it. When
So-
he was asking me questions about what happened, if I've been arrested, I technically I didn't know.
So if he testified at the hearing that we have the transcript for, that he talked to you on September 20th and your arraignment was on August 25th, September comes out for August, right? That's a mistake. That's what you're saying.
Because I came to my hearing and we were talking about it, and he was agreed that when he called me, I was unaware of what was going on.
Okay, so here's the thing. I understand everything you're saying. I understand your statement, but my question is very specific. At the time that Agent Winterton was testifying at this hearing,
Mhm.
he said he spoke to you on September 20th, 2021. Do you remember that testimony?
Yes,
Okay, what you're telling me is he must have been wrong on the date because you spoke to him before August 25th. Is that what you're telling me? And if you don't recall, it's okay. We'll move on.
okay. Yeah, because I don't remember.
Okay, that's okay. I know this is a nerve-wracking thing. I just want to make sure that if you believe you spoke to him more than once or anything like that, that's okay. You don't have to cry, okay? If you want a minute, I'm just asking you questions about the timing of it, since the court appearance is reflected in that paperwork. Okay, so did you just, yes. I'll ask her. As far as, are you okay? You want a break?
No, it's okay.
Okay. These are just questions I'm asking so that I understand what's happening when they're asking you these things in the hearing versus like today.
Yeah.
Okay, and I know you don't have like everything written down, and if you want to look at what I'm talking about in the hearing, because I don't want you to feel like I'm
No, I know.
bringing surprises on you, you can look at it. I'll give it to you. Would you be more comfortable if I let you read it real quick? Because maybe that would refresh your recollection on the dates.
Maybe.
Okay. Did you have a, you wanted to- sorry, did you want to ask for some follow-up on that? So I'm gonna let my colleague ask you a question, okay?
I just had a. I'm sorry, Ms. Mesa Guzman, with respect to your gaming employee registration, that's when you get a job in any kind of gaming establishment, you complete an application. Do you remember doing that when you worked? It says it on here that it was a TAO group.
Yeah, so I left. I was about to leave Resort World, and that's when I get transferred. I got the job at Tao, and that's when they obviously to work as a bartender in a nightclub, I needed a service card. So that's when I applied for the changing location.
Do you remember what date that was
No,
about?
because I remember I got hired and I started working, and then I don't know when my manager or the human resources actually, because they had to send a letter for me to exchange it, and I don't remember or have a date when my employee did it.
Okay. I'm looking at it looks like it's your application summary. I'm assuming it's correct. I mean, it's part of the state record, but it's dated July 23rd of 2021. Does that sound about right?
Yeah,
When
that's
you would have done
when
your
I start,
application?
yeah, when I start probably working in there.
Okay. In that application summary, you indicate an arrest history. You say that you were arrested, indicted, or received a citation. Was that disclosure with regards to this incident?
No, it was my DUI in 2019. Because
Okay,
I am aware, because I was aware. So if I knew something as a, I would have put it right away.
okay, so at that time you disclosed because of the prior incident, not because of this one?
Yes.
Okay, I was concerned that maybe we
No,
were
it
talking
was, I got a
semantics.
DUI in 2019, and that's
Okay.
what I put when I applied for it.
Okay, so you were aware of that and you knew you had to disclose it and you did. Your testimony is that this other incident regarding the domestic violence
Mhm.
incident, you weren't aware of it at the
No,
time you filled
no,
this out, and that's why
no,
you didn't include it.
no.
Got it. Okay. I just wanted clarification. Thank you.
Okay, I just didn't know if that was related to my line of questioning. My point is, gaming control officer called you, right? And asked you about this.
Mhm.
And you said nothing happened. And then you said, I don't want to talk about it anymore. And that testimony went unchallenged, basically, at the hearing.
I'm-
That's all I'm trying to ask you.
Yeah, he did call me, and I completely remember. I know, but I didn't know. At that point, I didn't know what I was getting charged. I didn't know. My lawyer just told me you have a warrant for arrest. We're gonna find out what's the reason, and that's why I told him.
Okay, well, I think, I understand what you're saying. I think what I'm gleaning or understanding is that you believe the officer may have been off on the timing because you're putting one after the other and he's putting, right?
Backward.
Okay, understood. I understand that's your position. So let me start down on this side. Everybody has the ability to ask you questions. Again, if you want to read the transcript and take a minute, you're going to ask anything about the transcript. Maybe I should let you read it real quick because I get the sense that you maybe haven't read it. Have you read it recently?
Mm-mm.
Do you have questions about the transcript?
I have a question about her definition of arrest.
Okay.
If I may?
Mhm.
How are you? Thank you for
Good.
coming. I know this isn't easy and we're not trying to make it difficult for you. We're simply trying to ascertain clarity of the record because you're technically under oath. So we just are trying to
Yep.
understand what happened in
Yes.
the timeline. So I do appreciate that when you filled out your GR application on July 12th, 2021, you had not been physically arrested at that time, correct?
Correct.
And the incident occurred on November 25th, 2020.
Correct.
And at that time, you had not been physically arrested.
Correct.
At that time, you were not cited. You did not receive a citation because you took off after
Mhm.
you shot him in the forehead with the pellet gun, correct?
No.
What happened?
It was just it was between me and my boyfriend.
But you left before the police arrived, yes or no?
We were arguing, and that's when I left.
Did you leave before the police arrived?
Yes, I didn't know it was
Okay,
police
so you didn't
involved.
receive a citation
No,
or anything at that
I was
time?
not even aware that.
Okay, that's my point.
Yeah.
So the next question I have for you is Chair Tagliati went through great details to explain what we understand from the record before us, your appearance in court, your walk across the street to get fingerprinted.
Yes.
Do you consider that an arrest?
Yes.
Okay. So you understood at that time that you were arrested, even though you didn't spend time there, you didn't get handcuffed. That was in your mind an arrest, and that was on August 25th, 2021, correct?
Correct.
Is it your testimony today that you received a call from an agent at any time before or after the August 25th, 2021 arrest?
I know he called me
Before or after?
before. He called me 2 or 3 days before my walkthrough because I told him I'm gonna have a court date on Wednesday, and that's when I'm gonna find out exactly what's going on.
Okay, but when I look at your testimony, and you'll review it in a moment, you stated allegedly when he called you allegedly on September 20th, that's what the record has, that's all I have, that nothing happened. When you said nothing happened, and you'll review it, you can answer it again later. I just want you to focus on that. When you said that, exactly what you meant. If you meant nothing happened at your boyfriend's or at the house with the pellet gun, or nothing happened in terms of you hadn't been arrested yet. I'm just trying to understand what you mean by nothing happened. And don't answer that yet. I just want you to have that in
Okay.
mind and take a look at the transcript so we can make sure you are fully apprised of the record that we have before us.
Okay.
Okay?
So let's, mine has highlights on it.
It's okay.
too.
It's okay.
And so
she
we're
can
gonna
have
give
mine.
you a clean copy because I feel like you should have the opportunity to read this and have it fresh in your mind so that you kind of understand the context of the questions we're asking, okay?
And specifically, when you look, you can take your time and read the whole thing, but I'm focused on page 5, starting on line 5 through line 16. And I'll write that down for you if you'd like. Page 5, lines 5 through 16, sir. Sir? Thank you. That's my specific.
You don't have to stand. Why don't you take a minute? and
Chair,
sit-
can I ask a follow-up question just before she does that? Because the timing is mixed up in my own mind. When you filed this gaming employee registration application on July 23rd, were you already working at the TOW?
Yes,
Okay, because it says that when he called you on September, whatever, September
I was in
20th,
I think I was in the, I don't know, I was in the process to start working. I know I was already hired. But
but it
sometimes
says that was at Resorts World, so that's why the timing doesn't make sense to me.
I was still employed at Resort World.
In September?
Yes,
Okay. Okay, well, that's because of it wasn't open yet.
I mean,
Well,
it was
yeah.
open already. I was working the entire time at Resort World. I left, I think in November. It was just a summer job. It was for the pool. But
Okay.
I was employed at Resort
Okay,
World.
I was surprised. That helps then. That was the confusion in my mind, that generally by the time you do the employee registration statement, you're either at the job that's stated on that, or you're pretty close in time to being there.
Yeah.
So the timing was throwing me off. Thank you.
Okay.
And yeah, if you want to take a moment and have a seat to read it, that'd be.
Yeah, you don't have to stand here at attention and read it. You can sit down and read it. Thank you. Okay, so we're gonna go back on the record. So, did you get an opportunity to read the transcript that we keep asking you about?
Yes.
So that's why we want to let you read it. Okay. At this time, Commissioner Brown, I think you were asking questions and you had follow-up and you gave her some specifics you wanted her to look at.
Thank you. Have you had an opportunity to review page 5, lines 5 through 16 of the
Yes.
transcript? Okay. Can you explain to me what you meant when you said nothing happened in connection to the question that was posed to you and the question that was allegedly posed to you as set forth in the record? I asked Meza about being arrested for the domestic battery. She stated nothing happened. I explained to her I had the police report and she was obviously arrested. Meza stated, I was never arrested. And this phone call, the interview, allegedly took place on September 20th, 2021. So what do you mean when you stated nothing happened?
But I mean that when he was asking me, you got arrested, I said, no, actually, I never got arrested. Nothing happened to me because I left. I understand because I left the house. So I just found out when that happened. I just didn't know like the cops were involved. I didn't know anything. I found everything the moment they told me you got a warrant for your arrest. We have to go to court. That's when for me, and when he was asking me all these questions, I didn't know what to say because I had no idea what was going on. I said nothing happened. No, I never got arrested. Nothing happened to me. I just left, and I have never heard anything since. And I have a court date on the 22nd, and that's when I'm gonna find out exactly what's going on.
Okay, so it's your testimony, contrary to the record that we have before us, which is closed, that you conducted this interview before you were arrested and before your court date on August 25th, 2021. Yes or no?
What was the question again?
Did you have this interview when you said nothing happened before or after you were arrested?
Before.
It's just not clear from the record. And I'm not sure that I can consider that because I think the record is closed. But if I could just say another thing, really, regardless of the timeline, I do believe that you were honest when you filled out the GER in July of 2021, where you acknowledged a prior arrest for the DUI in 2019.
Yes.
So to me, the timeline is really not as important as the conduct that you participated in November of 2020 and the criminal conduct, to be specific, that rose to a charge of a felony with the pellet gun. So that's really the issue for me. The timeline of, oh, I think I spoke to him before I was arrested or after I was arrested. That's one issue, but I have a whole separate set of issues with what you did and how you conducted yourself in connection with the incident that occurred in November of 2020 and the impact of that on your ability to continue to work in a gaming establishment. That's my concern. I appreciate us trying to clarify the timeline, and I still, based on the record, I think that you spoke to him after, but you're saying you spoke to him before. Notwithstanding that, I do note that you seem to be honest about your arrest history, because in July, you were not arrested. And you state here that you were arrested in relation to 2019, but I'm still concerned about the genesis of this entire issue, which is what you did in November of 2020 in connection with your boyfriend. So that's my concern. And I'm not saying I don't believe in second chances, but I'm struggling with the timeline of how much time you need. I know it's been over a year since the incident.
Yes.
But it still occurred, and I understand you've taken classes. Can you tell me about the classes you've taken?
So they told me I have to do I have to pay a fine, which I did already. I have to do community service, which I finished everything. And I'm doing domestic violence right now, and I would have done it already, but I have to take 1 week at one class every week. So I still have probably, I think I did half already.
What kind of community service are you involved in?
I went to the park and pick up trash and do what community services. They gave me the whole time to do it. I finished my community service in 2 weeks.
And what have you learned so far from your domestic violence courses that have helped you grow?
It did. I thought first I thought I didn't have a problem, but I realized it is a problem. I've been working on it every single day. I haven't been in trouble since, and I have never been in trouble in my life before.
Other than the 2019 DUI,
Yeah.
not with domestic violence. I have no further questions at this time. Thank you for your honesty.
Ma'am, I know it's a very difficult time for you to appear before us, and you're asking for a second chance. The record, as Commissioner Brown put forth and succinctly in your responses to Chair Tagliati, I'm not even going to go with that. I'm just going to assume that there were issues with that. I'm just concerned on what happened. And I'm very concerned with the time from when it happened to now. My own opinion is not enough time has passed for us to do anything other than go along with the recommendation. What happened, there is no reason for why it happened. I saw nothing in the record. It was self-defense. You were angry, obviously from the record, you found your boyfriend with someone else. Did you even know it was a pellet gun? Not that it matters. You just picked up a gun to shoot. So it could have been a handgun for all you know, correct?
Correct.
You were charged with a felony. You shot someone in the head. And that's not anything that I think this body can say, all right, let's give her another chance. I just don't think it's time. So with that, I turn it over to my.
Any other comments?
She's answered.
I don't have any other questions.
Excuse me. Let me do this. Let me ask you if you have anything else you want to add. I know you made some comments at the beginning and then you answered questions. Is there anything else you want to add before there's action on your case?
Well, I know what I did is wrong, and I accept it, but I feel like I always been a good employee. I have never had problems at my jobs, ever. Right now, obviously, I cannot work in the gaming industry, but I have never got fired. I have always been a really good employee, and I know what happened is bad, but I don't think that should be affecting my job.
Well, before we entertain a motion, I will simply say this. I will say that, the problem is that the kind of environment that you want to work in involves alcohol. It involves sometimes, especially in a club, right? People who are engaging in risky behavior. They might have their own. We hear about things that happen in clubs all the time, right? And so I think the point of Commissioner Cohen is well taken is that you haven't completed your domestic violence classes. Okay, that's number one. Number two, we cannot send a message, or at least I can't send a message, that you can grab what looks like a firearm, not be real sure what kind of firearm, shoot at someone in a moment of heat of passion, and go back to a gaming establishment to go to work in a club within the next however long, not having finished and not having had some passage of time, not having finished your domestic violence classes, not having, which means your case is still open, which means you are still on informal probation. In my view, I just can't have that. The other thing that I take issue with, but really isn't the reason for this decision, it's just a cautionary comment to you. It has nothing to do with why I'm going to vote the way I am. But if in going forward, because you're going to have the opportunity to have seek a review of this after the passage of time, you're going to get to come back, right? You're going to get to make another a showing if it doesn't work out for you today, and I don't know what will happen, but I just know what I'm going to do. I would strongly suggest that when someone from the Gaming Control Board, an agent, takes, on taxpayer expense to investigate your case, you take the time either to consult with your attorney and have your attorney present during that conversation, make sure you're super accurate on your times and your dates, and that you're cooperative. Okay,
Okay.
okay. I don't have anything else.
You want to?
I'm looking for a motion and then we can have discussion.
Um, Thank you, Chair. Um, I would move to ratify and affirm the findings of hearing examiner Chan Langzabath and the order of the Gaming Control Board regarding this matter.
So are you moving to sustain it?
Yes, I'm moving to sustain and affirm the order.
Okay, so we have a motion pursuant to NRS 463.335 subsection 13 to sustain the board's objection to Ms. Mesa's registration as a gaming employee. Is there any discussion on that motion?
Thank you, Madam Chair. I find myself more sympathetic to Ms. Mesa than anticipated being reading the record. I think she's sincere in wanting to work, right? And working in a club is a lot better than working in most places financially, right? But we do regulate clubs for a reason. It's because they're environments that have had trouble historically. And it gets, I think that there may be, I think that it is plausible that there is some discrepancy in the time frame of the interview. I don't know, but I get back to the time issue as well. And um, and your answer to Mr. Cohen's question about sort of how you ended up with a firearm in your hand is what's going to make me support this vote today. If it had been a 22, wouldn't even be standing, right? Because be charged with murder. So I think right now I'm going to support this, and I hope that you continue to do the work that you need to do, and that when you come back before us, we can support you. Okay. Thanks.
Thank you. Ms. Mesa, I do have to say, I know maybe at this specific moment, you're probably not feeling very lucky, but I think if you reflect and look at how things could have turned out in November of 2020, you're very lucky you didn't kill somebody by shooting him in the head, because you would not be here trying to have the opportunity to have the ability to work in a gaming arena. So I do hope you understand that you're actually very lucky, and you will, as Chair Togliatti said, have the opportunity, if you so wish, to come back before us and show us that you have done what you need to do to give us enough understanding that you have reformed, that you understand what you've done, and you're simply very lucky you didn't kill anybody that day or that night. So don't feel unlucky. And we hope to see you again if you so choose to appear before us, but I have to support the motion to sustain the recommendation from the board at this time. I understand. And thank you for coming and for your time. I know this wasn't easy. It's not easy for us either, but we do have an obligation and duty to Nevadans. And I'm sure one day this will be a distant memory, and that you will improve and move forward. Thank you. Thank you.
Any other discussion before the vote?
No, I just wanted to add the same. I mean, I wanted to encourage you to keep going with your domestic violence classes. I think, that beyond the fact that they're going to help you if you ever have to come before us again, they're going to help you personally, because this could have gone really, really bad had you picked up a different type of weapon. So, I just want to encourage you to do that. I do feel you're being honest. I'm not sure what happened with the timing or if it was confusion, but like Chair Togliatti said, this is your life and your burden. So if you're ever in a proceeding where you have to be faced with questions, make sure your timing is beyond reproach. Write it down if you have to, so that you can challenge if anybody misspeaks. I don't think anybody willfully would have misrepresented the timeline, but if anybody misspeaks about the timeline, you need to take the initiative to correct that, because this is your life, and it's going to affect you. And I realize that this isn't how you wanted things to go today, but you look very young. I think you don't have much of a blemish in your record other than what you disclosed in this incident. So I do hope you take this time to maybe just focus on your classes and on yourself, and come before us at another time.
Thank you. Anybody else have any other discussion? Commissioners made a motion to sustain. All in favor, say aye.
Aye.
Any opposed? Unopposed. Good luck.
Thank you.
Thank you. You can, why don't you keep it? So that
Oh,
if you
thank you.
choose to come back, you'll have all your paperwork and you'll be ready.
Do you understand? I'm sorry. Do you understand the timeline? I believe it's in a year. Is that correct? You can seek reconsideration after a year from today's decision? Is that when it runs from?
I think it was from the hearing. That's a good question, but I think it was from the hearing decision. Or the.
Yeah, I think it's.
Give us 1 second. We're gonna find out exactly, okay? So you can set your watch. No, I think it's their decision, not ours. Yeah, I think it's the board's decision.
So it's after,
But
okay,
we'll find out. Let's.
She's barred that whole time.
yeah. So are they checking? I just don't remember those stats.
Chair, I believe it's a year from today's decision per regulation 5.109.
So do you understand that a year from now, a year from today, you can seek review of this and you can have a new hearing? Okay? All right, thank you. Oh, by the way, I would suggest that all the paperwork related to your court case, it being closed, your certificate of completion to domestic violence, I'm not gonna tell you how to do it, but put your best case on. Okay? Okay. Sorry, just had to get my binder ready. All right, our next agenda item are administrative reports. If we could start with Chair Gibson.
Madam Chair, the board's next meeting will be March 2nd, Wednesday, 9 o'clock start. 9 o'clock will be non-restricted, 11 restricted, and it looks like we have a total of 8 unrestricted items and 13 restricted.
Thank you. Anything from the AG's office today?
Nothing today, Chair. Thank you.
Thank you. All right, Madam Secretary, let's close with our last agenda item, public comments.
This item is placed on the agenda to give the public an opportunity to comment on gaming related matters.
I'll first go to Carson City. I can't see a thing. There's no one there, right?
No.
Anyone wishing to make a public comment, please step forward to the podium. There being no one. Anyone here in Las Vegas? There being no one. That will close our public comment section. This concludes the Nevada Gaming Commission meeting for the month of February. We are adjourned.